Good evening, everyone. I'm going to call the April 1st County Services Committee to order. With that, I believe Justice Dennis has done us the honor, agreed to do us the honor of prayer and pledge. Justice Dennis, I'm going to cue your mic.
Thank you, sir. May we pray. If my people who are called by my name will humble themselves and pray and seek my face and turn from their wicked ways, then I will bless their land, and I will forgive their sin and heal their land. Our Heavenly Father, I do humble myself, and I ask that your forgiveness on our nation. I pray that we will seek your wisdom on deciding the issues that are before the Quorum Court of Washington County, Arkansas. Give us strength and guidance. Thank you that your Son, Jesus, paid for our debt and sin, and that he is risen. These things we ask and pray in Jesus' name. Amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Justice Dennis.
You're welcome.
And with that, we'll move to the adoption of the agenda. Do I have any motions for the agenda? Justice Lemming?
Yes, I had passed out some papers here for all the justice to look at and be thinking about it. And I'd like to add to the agenda to be able to talk about this and why I think it's important to the agenda. It has to do with the personnel policy and the personnel book, and that's what we're going to be working in, and I think that'd be perfect time to talk about it.
So you want to describe that as a personnel discussion, or what would you?
It is
for the agenda?
I want to change some writing in the handbook, in the procedure, but I want everybody to be thinking about it and talking about it and looking about it and how we got to go about doing it.
Okay.
It's an amendment.
Okay. So a discussion item for the personnel policy, the handbook?
The handbook.
Okay.
Section, it being page 68, employee discrepancy, termination, and grievance procedures.
Okay. I have a motion by Justice Lemming, a second by Justice Coger. All those in favor?
Aye.
Those opposed? That will be item number 8. Any other motions for the agenda? With that, do we have a motion to adopt the agenda? I have a motion to adopt the agenda. Did I hear second by Justice Rios Stafford? All those in favor? Aye. Those opposed? The agenda has been adopted. With that, we'll move into our monthly reports. Director Tinsley, would you give the juvenile detention report, please, sir? All right, sorry about that. Welcome, sir.
Thank you, Judge Deakins and the County Service Committee members. In the month of March, we had 35 intakes, the average length of stay being 6.51 days. The average daily population for March was 17.57. It was a busy month. The highest number of intakes were Battery 3rd, misdemeanor at 7. Of the 35 intakes from Washington County and Madison County, 18 were from Division 3, 16 were from Division 8, 1 juvenile being interstate compact. There were 8 total transports. 4 transports were law enforcement transports, and 4 were performed by JDC. Are there any questions that I may address at this time?
Questions for Director Tinsley? Thank you, sir. Appreciate
Thank you, Judge. Yes, sir.
With that, we'll move to the Sheriff's Office report. Sheriff Cantrell. Good evening, sir.
Thank you, Judge. Jay Cantrell, your Washington County Sheriff. You've got your report there with you, I hope. Calls for service is down a little bit this past month. Those are our calls for service relate to our enforcement deputies that are out working out in the field. Detention intakes are up a little bit. We got to send more to prison this past month than we did, as you can see, the year previous. The state has taken a few more this year since the first of the year, but we still have 125 holding for Department of Corrections currently. That's as of today. Still have good pretrial numbers. Our female count continues to creep up. We're at 150 female detainees today, and that's up about 20 more than what we typically see. So no rhyme or reason yet that I'm able to identify why that number is up. One nice piece of information is our average prior bookings has been running about 8 to 8.1 is down to 7.3 on the average prior bookings, so fewer repeat offenders coming into jail, so that's usually a good sign. If we can keep working on that recidivism and figure out how to keep people from coming back, it's always a good thing. So, that's kind of the nexus of our report. Obviously, I know there's some heavy weather moving in, so I'll try to be brief. County Judge and I attended a meeting today with the Northwest Arkansas Regional Emergency Managers and talked about the eclipse coming up next week. In spite of our best efforts, it's still going to happen. We just don't think that Northwest Arkansas is going to be affected like the central part of the state, that Texarkana up kind of through the northeast corner that's going to be in the totality. So we're kind of gearing up to be an assistance to our partners next to us that may have trouble. The National Forest folks believe that they'll have a lot of ATVs and side-by-sides out riding the dirt roads looking for a high point vantage point or high ground vantage point to watch it from. So the roads could become clogged up with side-by-sides, ATVs, different things like that. Out in the rural areas, we'll just make sure all our deputies have a full tank of fuel that Sunday evening before. We know food and fuel will probably be the things that get taxed the most on this Monday. So it's kind of the preparations we're taking, and we've got extra food on hand. We'll have on hand for the jail in case our transportation arteries get clogged. We'll have extra fuel for our generators in case our power grid goes down for whatever reason. But hopefully we come to you next month to say we grossly over-prepared, and for that we do not apologize. that we're happy we over-prepared. So anyway, that's what I have. I'll be happy to answer any questions or.
Questions for Sheriff Cantrell? Justice Coger?
Thank you, Judge. Sheriff, could you give us an update on the COVID jail mitigation expansion at the county jail, where we are on that? And I may have some questions after that, but if you could specifically speak to the study, the phase 1 study that Hyatt, Jackson, and Nabholz are supposed to be partnering to prepare. If you could speak to that, please.
Well, I know that they have come together and are starting to determine what we can build with the amount of money we have. Obviously, since we first began this project some years back, prices have increased. So to see, I don't have a final product. I haven't seen yet what they project that we'll be able to afford in the way of remodel and any thing that has to do with that COVID mitigation project. So don't really have much to report except they had a meeting today with our buildings and grounds, our maintenance supervisor, to talk about some things like exercise yards and different things that they are trying to figure out a way to save money and to get the most product we can for the amount of money we have.
So if I understood you correct, then you haven't seen the study that we paid the $47,500 for phase 1. You haven't seen that?
I haven't seen that particular document, no.
Okay. And
Well, I take that back. Maybe I've seen it, I just don't know that I've seen it referred to by that name. I have seen a document where they've put together some timelines and some different things that they're going to suggest and recommend, but nothing about a study that I've seen.
okay. From what you've seen, are they still considering 230 new jail beds?
I think it's too early to come up with a number. It's going to be expensive to build anything right now. Right. We know the cost of goods and services have gone up all across our region. So, I think it's too early to know what kind of jail beds might be included, if any, you know, if we can even afford any. So we'll have to see how that plays out. But hopefully we'll know something soon.
Okay. And how many are sleeping on the floor today at the jail?
Today, the number I just looked at was 131.
131? That's up a little bit from last month.
Yeah, it kind of ebbs and flows depending on the population class that we have at the time.
And how many in the jail have COVID right now or have been diagnosed with COVID?
I don't know. Randall, do you know what our COVID number is right now? I think a couple in medical holding that came in.
Okay.
It was the last number I saw. You know, we don't have a block of them today.
Okay, that's all I have. Thank you very much, Sheriff.
Any other questions for Sheriff Cantrell? Justice Dennis?
Thank you, Judge. So when you said that they came in with COVID, so do you have a way to quarantine them now?
Well, we have, yes, if somebody comes in with COVID, you know, we don't turn them away. So we find a place to house them. We've got 2 holding cells in our medical ward that can hold 2 people each. And those are negative pressure holding cells where the pressure is less in that cell so that when you open the door, air rushes in instead of rushing out. So it goes in and up through the ventilation filtration system. So we can house 4 people there, and then if we have more than that, then we have to empty out a cell block and then start isolating people there. If we can catch them early, before they get in contact with general population, then you know, we can isolate those people. But you know, once they get in and expose other people, then we have to consider those people as potential COVID patients and then isolate those people as well, those exposures, and wait the 5 to 7 days to see if they do contract the virus.
Well, from what you said, I kind of look at it like this. I went to the hospital with my wife, and they asked the question. They said, have you been exposed to COVID or the flu? And my answer was, yes, I have. I've been waiting in your waiting room for an hour and a half, and I guarantee you I've been exposed to COVID and the flu. And she said, well, you're an honest person because every half of them out there have it, and everybody that comes in is exposed to it.
Right.
I'm looking forward to you having a little bit better facility to quarantine the prisoners so that it does protect them from COVID and other diseases that might come down the pike as we go forward.
Thank you, J.P. Dennis.
Thank you.
Additional questions for Sheriff? Thank you, sir.
Thank you, sir.
Right. With that, we're going to keep right along moving. Up next is item number 6 on the agenda, an ordinance amending Section 9 of the introduction section of the ordinance 2018-50, the Washington County Employee Handbook. Director Burchett, would you like to come up here and give us some quick background on this for the justices?
Good evening. As we have been going through our handbook and trying to get some policy revisions accomplished, this is a policy that has a lot of meat to it in regards to onboard. It touches every aspect of an employee's life cycle at an employer. And so it's very, very important that we have our guidelines clear on how we handle drug and alcohol-free workplace, and basically what that is. We have to define that as a county. And so that's what this policy hopes to accomplish. It is the Arkansas Association of Counties sample policy, tweaked slightly. There were some points of clarification that the AAC left up to us, and so we clarified those within this policy. And when this went before JSAP, all of our elected officials were in agreement that this was the direction that they would like to go with the maintenance and management of this program. We've done a lot of legwork leading up to bringing this before you all. One of the areas in this policy that took some work was classifying each of our positions in the county as whether or not they're going to be safety sensitive or not. And so I think we pretty much have that feedback from all of the managers and electeds in the county at this point in time. There are some other administrative type things that we're gonna have to get kind of lined out upon this passing, if it passes. But we're prepared to do so in HR. So anyways.
Questions for Director Burchett? Justice Lemming?
Yes, thank you, Judge. I'd kind of looked over this one, and it looks like we're going back to what we originally had years ago, except we're really dealing with the medical marijuana. But I think if you hold a CDL driver's license still yet, I don't think you can drive a truck with medical marijuana. Is that true or not true?
That's correct. So
this goes back to, go ahead and answer your question. I'll think about what my question was.
Okay, so this policy is in compliance with the federal DOT regulations. So
That's
when I say
basically what it
safety
is.
sensitive, that all of our heavy equipment operators, they would be considered safety sensitive. Anybody who carries a firearm, it
Right.
defines it within this policy, what a safety sensitive position is.
So they no longer could work for the county with a medical marijuana card.
That is correct.
That's
That's
good.
correct.
That's
And
good.
they can't do that right now anyways in those positions, specifically law enforcement and our DOT employees,
Well, you wouldn't want them to.
because that's federal regulation,
That's
right?
right. That's
yeah.
federal law,
Yes.
so they can't do that as we speak.
Correct.
So is this, it don't make sense that it says here, it won't be reported to the employer if it's positive. Now, why would that be?
So if it's a non-safety sensitive position, it won't be reported to the employer that whether or not they have a medical marijuana card or not. That is their private information. So that's why you have an MRO, a medical review officer, that screens your drug test results. They may know whether or not this individual holds a medical marijuana card, but we as the employer do not have a business need to know that in that situation.
If they're your employer, you don't have the business to know?
Not if they're a non-safety sensitive position. No, sir. That's their private information. And so that's why we hire an MRO. We contract with them. They're a doctor, and they get that evidence. It's just like let me give you a different example aside from medical marijuana. Let's say we have an individual that we want to hire. They're being hired in a non-safety sensitive position. They're going to go do their pre-employment drug tests. That MRO, let's just say that individual is right now prescribed hydrocodons. They're going to most likely test positive for hydrocodons on their pre-employment test. However, what gets reported to us is going to be based on whatever their dosage by their medical doctor was. So if their levels in their test are within the legal limit, that MRO will tell us they're negative because they're legally allowed to have that amount in their system. Whereas if it's above that, we're going to get a positive result, and then we would follow our procedures.
So basically, it goes back to where it holds truck drivers, heavy equipment operators, everybody that's heavily sensitive is at a higher standard than everybody else.
Correct. It's always been that way.
Well, I know, and it's
Yeah.
always been wrong because I feel like it's been wrong because, and I'm not down in truck drivers, but it's kind of like race car guys are in one group, motorcycle riders are in a group, truck drivers are in a group. It's just that type people, they like to party. They like to run around. They like to ride motorcycles, and that happens.
Yeah.
So, but a lawyer, or a doctor, or a judge, they can go party and they can get in trouble, and it don't come back on them. They don't lose their license because of that. So that's a different standard. But
Right.
but that's life we got to live with. That's our government for us.
Right.
But that's still not right as far as I'm concerned. But it is what it is.
Yeah. That is
But basically, this
unfortunate.
goes
Yeah.
back to the original that Washington County's worked off, I think, for years.
Okay.
Except a few things y'all have tweaked and adjusted.
Yeah.
So I like it.
Okay.
Justice Simons?
Thank you, Chair. Thank you, Ms. Burchett. So I have a whole lot of questions on this one.
Okay.
So bear with me.
Shoot.
Does the county legally have the ability to deny employment carte blanche across the board for anybody that pops on cannabis, whether they have a card or not, whether they're security sensitive or not? Do we have the legal ability? You hear Arkansas is a at-will workplace.
We're going to get into some personal rights issues
Sure.
whenever you start talking about that. So I don't really want to be the one to answer that. That's a legal question for our attorneys.
That's a
Yeah.
big question.
That
I
is
have
a
moving
very
forward
big
because
question, yes.
I would like to know what position at the county is not so important that they can have any cannabis on them. I mean, I understand there's certain places, certain employers that have chosen to entertain, hey, if you have
Correct.
a medical card, sure, we'll take that into consideration on your
Right.
pre-employment. I don't know if there's a position at the county that I'm comfortable with accepting that amount of risk. And it's interesting that you say that this comes from the ACC or the AAC. I want to know what points were amended, right? You said this was kind of a template that came from the AAC. What was tweaked, and is it to Washington County's benefit? Is it more conservative in the tweaking to make it
The only
more
thing that was
regulatory?
clarified, I guess tweak is the wrong word, clarified in here, is AAC, when it starts talking about pre-employment testing, we have the option of pre-employment testing everyone initially, or you have the option of classifying your positions into safety sensitive, non-safety sensitive, and making the distinction that you are going to pre-employment test certain groups based on that classification. And if you're going to do that, you have to be consistent and treat everybody that's classified the same way. So
How do we currently do that?
how do we currently do that?
Do
We
we
pre-employment
designate-
test everyone.
And so this proposed
Changes
amendment
that.
is changing it
Yes,
from
that is
treating
correct.
everybody the same to having a different designation for certain classes of employment.
That is correct.
Okay.
You don't have to do that. That's an option. This is the option that AAC designed for us under the law. This is legal. You do have the right to do this as an employer. You don't have to, though. The other option is you do it for everybody, blanket, for pre-employment. Now, when you get into other things like reasonable suspicion, random testing,
Sure.
all of that, then depending on how you have your employees classified, then you have different rules there too, how you have to handle that under the law.
Obviously, there's certain classes of people who just, they don't need to have any kind of cannabis in their system or any other
Right.
illicit drugs, but,
Right.
I had it, hold on.
Okay.
Do we have, or can you provide a list of, maybe not employees specifically, but positions, titles that are non-security sensitive?
Yes, I have those.
Okay.
Yeah, because we've went through that
Sure.
over the past couple weeks with all of our electeds and had them kind of give us feedback.
Sure.
HR started. I told them what I believed these positions were based on the duties and responsibilities in the county, whether they were non-safety or safety.
Okay.
And then I sent that out to them, and then they provided me feedback as to whether or not their positions needed to be safety or not. And it was based on the definition provided within this policy.
Other than maybe some cost savings on not having to do the pre-employment drug screening on the front end for non-security sensitive employee, potential
yeah.
prospective employees, is there another advantage to the county to not screen certain individuals?
I guess it can potentially speed up the onboarding process, potentially. But you have another aspect of pre-employment onboarding that involves a background check, and that is dependent on the applicant. So we can't really tell you this is how long it takes to onboard, but sometimes a pre-employment drug test, if the applicant doesn't go and do what they are told to do, go to the facility at their scheduled time or whatever it may be, that could delay
Sure.
the onboarding process even further.
My background is insurance, and so obviously I'm a risk mitigator at the heart of all things. And this, my fear, without really digging into this and understanding it better, is it seems like this is going from a more heavily regulated pre-employment process of carte blanche. Let's drug test everybody and make sure nobody has anything in their system they don't need to opening the door for certain individuals that we feel it might be okay if they have the, and then to me that opens up more risk for liability. Again, I can't think of a position held by a county employee that we would feel comfortable allowing them to have any kind of mind-altering substance in their body at any time.
Okay, right, I sort of agree with you when it comes to the liability part. So here's the other thing about this. So we're talking just pre-employment right now. There still is a very big need to designate our workforce as safety versus non.
Okay.
Because when you get into reasonable suspicion, when you get into randoms, you need to have those defined because you don't randomly drug test every single position in the county. You can't do that. There are laws surrounding that.
Okay.
Random testing, okay? Reasonable suspicion, you can do that, but we have to have training, a training program in place. There's state law that dictates how we have to handle that. So it's not just pre-employment. Now, in this policy, yes, it does say we're classifying our employees. Those who are safety sensitive will be subject to pre-employment. Those who are not will not. We don't have to do that. We can say we're not going to classify them for the purpose of pre-employment and go back to everybody's going to be pre-employment tested, but still define everything else.
Okay.
So we do have that option. And, you know, just because you pre-employment test somebody doesn't mean that once they're hired,
Sure.
they're not going to go get their medical marijuana card. They're not going to go, you know, use marijuana legally in the state. It doesn't mean that they're not going to drive. I don't know. We're in the middle of different states that do have it legally,
Sure.
you know, legal recreationally. It's not going to mean that they're not going to, at some point in their employment, go over state line and go use and come back. So they may have it in their system. So what we have to be worried about is what they're doing while they're here at work. Mm-hmm. What's that liability for us? What do we want Washington County to be viewed as an employer? So that's kind of where I come from with this policy. What can we legally do? Also, how do we want to be viewed as an employer? What are our expectations of our workforce?
Exactly.
Yeah.
Just because we can doesn't mean we should.
Correct.
Okay.
Yeah.
Thank you so much for filling
You're
those
welcome.
off the cuff.
No problem.
Just a second, if you, if you can, scoop, oh,
Hear me? Is this good enough? Under the current law in Arkansas, an employee who has.
just a second, you got to get real close to that, we still can.
I'll just lie down on the desk. Under the law as it stands today, any employee could have a medical marijuana card and still be hired by Washington County. So not any employee, any non-safety sensitive employee could be hired today.
Can be, but I guess my question, and maybe I didn't phrase it right.
Under the law, they cannot be refused employment solely because they have a medical marijuana card. And the nature of testing for medical marijuana is that it'll be retained in the system for a length of time. So to have it in the system is not the same as being under the influence.
Sure. Okay, so that was my question is, the county doesn't have a right, even though we hear that it's a right to work state and we can choose who we do and don't.
The purpose of the medical marijuana amendment was to protect the card holders from discriminatory actions by employers. How's this?
There you go.
The purpose of the medical marijuana amendment, as it stands in Arkansas today, is to protect card holders from employment decisions by their employer that are based solely on their holding a medical marijuana card. And the nature of testing for medical marijuana is that it'll show up in the system for a certain number of weeks afterwards. And so an employee who may test positive would not necessarily be under the influence. And so the system works in that while that employee can become employed, and that's fine, if they ever behave in a way at work on the clock that caused anyone to suspect, have a reasonable suspicion that they might be under the influence, marijuana, meth, alcohol, whatever it is, certainly there's a process in place to conduct a drug test on that employee at that time, and then of course they would lose employment if they tested positive, even if they held a medical marijuana card. So the object of this system that we're proposing is to allow those protected employees to gain employment, but if they should be under the influence on the clock, then they would lose their employment.
Justice Fleming?
Thank you, Judge. Boy, that even raises a bigger flag. With all that said, if they get in a dump truck and kill somebody and they, that really opens a book to me, it looked like.
A dump truck driver is
sensitive.
going to be under CDL, and they're safety
Anybody
sensitive.
CDL has that problem.
They will be tested pre-employment, and a medical marijuana card will not protect them from a positive drug test.
Thank you. Judge, can I ask Simons a question?
Justice Simons, you open to that?
In the insurance world, what do you think that'll do to our insurance, our county insurance? Just a gut feeling. I'm not sure you can't tell us that, but that's just a question.
Well, we've seen rates steadily rise without that issue, so you might imagine how that's going to only exacerbate problems.
Counselor Baker?
Again, the purpose of the medical marijuana amendment. Well, drug-free workplace policy is an insurance rebate policy. That's the purpose of it, is it helps us retain a discount on workers' compensation. So this is an insurance premium reduction policy. It is. It's compliant with the law as proposed, and it will accomplish the same result.
Justice Coger?
Yes, thank you, Judge. Ms. Frechette, you mentioned something about administrative things will have to be outlined if it's passed, but wouldn't any administrative things already be in here? I mean, what are you talking about?
I apologize for that. Clarification. So when I said that, I meant, for example, providing a consortium list of those that will now be randomed to our random consortium company that we contract with, who would carry out those random drug screenings on the safety-sensitive classified positions. So little things like that. There's a cost involved with that, like with anything. But there's also a cost to pre-employment screening. So you got to weigh which way you're going to go. Either way, there's going to be a cost to this.
Okay, I just wanted to clarify, see what that meant. But,
Yeah.
But also, so that company you're mentioning, is that Courthouse Concepts?
No, ma'am. Arkansas Association, I cannot talk. Arkansas Association of Counties holds a contract with a company called National Med Test, and they already handle our DOT compliance program. And so I actually was on the phone with them today, finding out the details of how this will come into play and what our cost will be. And so they would be handling at that point our non-DOT but safety sensitive consortium for randoms. So we would have to send that to them, and they manage and monitor that. They have an MRO on staff, a medical review officer that reviews all the tests, and then they send us the results to HR.
Okay, so what does Courthouse Concepts do? Because we pay them for drug testing.
So Courthouse Concepts is a collection site for us, just like occupational health or conservative healthcare. I can't remember which name they go by now. They're in Lowell. So we have multiple testing sites around the county that we can send an individual to if we're contracted with them. And so they are the collection site, but they're not actually the ones who do the test. They're not the lab. They take it and they send it to our lab because there has to be certain procedures followed, especially when it comes to DOT.
Okay, thank you. That's all I had, Judge.
Justice Lyons?
Thank you, Judge. I guess I don't understand why we want to make the pre-employment less restrictive than it is today. It didn't sound like there was, it seems like there's no benefit to do it or not to do it. So I probably would fail to keep it the same and drug test all of them. So I'd like to make an amendment that we take that back to pre-employment testing is for all candidates.
I have a motion by Justice Lyons. Does it have a second? Second by Justice Dean. Any further discussion on the amendment? Justice Simons?
Thank you, Chair. I had my mic queued up to suggest that we table this for 30 days. Obviously, there's a lot of conversation and a lot of questions that some of us have. If we could table this for 30 days and come back to it, give us all a little bit more time to do some research and due diligence and readdress this, especially considering the weather that's coming in tonight.
I have a motion by Justice Simons and a second by Justice Dennis to postpone this for 30 days, the next County Services Committee. Is there any discussion upon that motion? Justice Taylor? Okay. Justice Leming?
Does the state law, because I work for the state, if you wasn't a sensitive person or card holder, you really couldn't be tested. Is there a law against that, or is that
If
the
you were
pre-employment?
a medical marijuana card holder?
No,
Oh.
I ain't, no.
Oh, excuse me. I'm just
I'll
trying to
take a
make sure
drug
I'm
test right now if you
understanding.
want one. I don't care. All I drink's tea and water. But, so there is no law that says pre-employment you can do a check on, right? Am I right or wrong?
I don't understand.
Well, say if you wanted to go to work for state of Arkansas and they don't have a pre-employment drug test, you just fill your application out and you go to work for them.
Mm-hmm.
Once you get through that one step, then you have to do a test. Ain't that the way it goes? Rather
Mm-hmm.
than do your pre-employment, maybe it's the same thing.
No, not necessarily, no. If you are testing and saying it's pre-employment, that has to be done before that employee starts work. That's the essence of a pre-employment. So it's before they're employed. Once you're employed, now your civil rights come into play, and you have some Fourth Amendment regulations and laws that you have to follow for that person's rights as a human being. And so you come into this invasion of privacy. I'm not an attorney, but it gets into that. And so you have to be very careful about how you treat somebody once they're employed in regards to testing them.
Well, I learned the hard way I'm a hard knocks guy all the way. I hired a lady on a Sunday. She went to work on a Monday. I drug tested her on a Tuesday, and it cost me $2,200 when they come to my office to do my check. It was crazy, but that's what happened. But I just don't. But she had a chauffeur's license, so that means she had to be pre. I couldn't use another business's report. I had to have her drug tested myself. So I just don't know if there's a state law against that, but I don't know for sure.
So you just said that she was a chauffeur.
She was a truck
So
driver.
it could have been that, and she could have been, that position could be safety sensitive under the law. That could be what did that.
Yeah.
Yeah. Now, if it's a safety sensitive position, once that person's employed, they are subject to random.
Yeah.
They're subject to reasonable suspicion, so, and they,
But that'll
they
cost
ought
you
not to
$22
have that.
That'll cost you
Yeah.
$2,200 if that happens.
Well, depending on what kind of contract you have with your servicer.
Okay, thank you.
Yeah.
Counselor Baker, do you have something to add to that discussion?
I just wanted to add that the definitions of safety-sensitive and non-safety sensitive positions are defined in the law. And so there's very little discretion in our list of, this might be one or the other. Very few, because the law defines those. Obviously, everybody at the sheriff's department, safety sensitive. Anybody at the road department, safety sensitive. So it's like clerks, receptionists, that kind of thing would not be safety sensitive, but it depends which department they work in. So all of this has been, I would not want anyone to be under the impression that we're just throwing darts and deciding who's safety sensitive or not. It's defined under the law. And then we have to double check and think about what are these job duties. And that's the process the county has to go through. But we are not assigning that. That's assigned by law. And then we just kind of verify and check and see what category they would fit into.
Justice Washington?
Thank you, Judge Deakins. I have a question for Ms. Burchett. It's actually a two-part question. So if this ordinance were to pass as written, what would be the benefit to the county? And the second part of that is, if this ordinance were not to pass as written, what would be the adverse impact to the county?
So the first question, what would be the benefit? So I say this loosely, cost, initial costs in pre-employment testing, and maybe the time frame that it takes to onboard somebody. However, like Justice Simons was, talking about insurance rates, there is the potential where if you hire somebody who potentially has any type of drug in their system, they get on the job, you hire them, and they get injured on the job, now it's a workers' comp claim. So now the county is paying a workers' comp claim. Depending on how severe it is, it could be very lengthy or it could be short. It just depends on the type of injury. So there is that risk. Not changing it, we're going to continue to pre-employment drug test everyone like we are now. The cost is going to remain, for the most part, the same as far as that goes. I guess that would be the difference, are those two items. I can't think of what other reasons there would be, unless Ms. Baker has some. Sorry.
I just wanted to clarify the workers' comp claim idea. If an employee were to have an accident that rises to the level of a workers' comp claim, if they did test positive for marijuana in that situation, that would be, it wouldn't matter if they had a medical marijuana card. Or if an employee had an accident, a safety-sensitive employee would be one who carries passengers. Okay, so anybody who would carry a member of the public is safety-sensitive. But an employee who's not, and they go out and have an accident on company time, and they test positive, and a medical marijuana card would not protect them from losing employment. After they're employed, if they have an event, whether it's an accident, an injury that rises to a certain level, or just behaving as if they're under the influence, that is not protected by the medical marijuana amendment, and they would lose employment.
Justice Hires?
Thank you. I just have two quick questions. Do you know the average cost of pre-employment drug screening per person?
So currently right now it's around $30 a person for pre-employment testing. If we were to move to a random consortium type testing, which we are going to need to do that anyways with our safety sensitive people, there is a cost to that, but the amount, so there's going to be an increase there anyways for doing that, but currently it's $30 a person, a new hire.
Okay, and then my second question, do you have any data on the percent that are positive on that
that are positive on pre-employment testing when we carry out pre-employment testing? No, ma'am, and even if I did, I don't think I would want to share that publicly with anyone.
Okay, I just think that's important data to know how much you're spending and how much it actually matters. But, okay, thanks.
Okay.
Justice Taylor?
Thank you, Judge. Two things. Number one, to Justice Washington's point, if you're sitting here selling us on this, and I'm not necessarily in favor or opposed to it, but, you know, HR issues they tend to compound themselves, and as we talk about this more, it just kind of snowballs. If you, in summary, were to give us the trade-off, like what's the benefit and the negative, because this clearly is a trade-off, that I guess is number one, is what are we giving up in favor of adopting this? And number two, you know, what is your sales pitch for me to vote yes on it? You signed up for this, not me.
Occupational hazard. So what's the benefit of this passing?
Right, yeah, and then what are we giving up in order to adopt this?
So overall, the entire policy, the benefit of passing this is we are defining what is safety sensitive versus non-safety sensitive in our workforce. We are outlining and addressing the medical marijuana act within our policy, which right now our current policy does not delve into that. And we are also setting up guidelines for reasonable suspicion, random testing, and outlining a disciplinary procedure, which our current policy does not have. So, you know, HR documentation is so important. So it's very important to have, you know, records and all of that outlined on how we're going to maintain all of this information. And so overall, aside from the pre-employment question, I think that, yes, this policy has a lot of positive things that we still need to highly consider that our current policy is lacking under the law, okay? As far as the pre-employment, like I said at the beginning, that was something that the AAC did point out in their sample policy, that we as the employer get to make that distinction on pre-employment. Do you want to classify your employees into classes? Or you can test everybody and treat them all the same. It's up to you. You're not doing anything wrong or breaking the law if you classify your employees into these different classes. The easiest way for us to classify them was safety sensitive versus non.
Because you're doing
okay?
that anyway.
The law already defines it for
Right.
us, why not go with it, right?
Right.
So we were already having to do that to accommodate a random testing program and all of that. So it would make sense for pre-employment to kind of flow with it.
Right.
But I understand everybody's concerns, I think, around the horseshoe right now about, you know, whether it be cost, treating everybody the same, and the risk involved in
Well, I
hiring
guess
somebody under the influence.
To further the question, so what is really the benefit from a hiring perspective to implement this pre-employment, you know, procedure versus the existing one, given the fact that you're saying like that was sort of the gray area where AAC said fill in the blank where you want to do?
Right.
Like, why do we err on this method? And then what's the benefit of that, I guess? Like more eligible people to hire? No?
No. So I would say the only thing that I can think of that may alleviate some is the time frame to get somebody onboarded.
Like the
That's
number of days?
the number of days it takes to get somebody onboarded. Like I said earlier, it's applicant driven, so whoever that applicant is, depending on their background, how long that takes. The pre-employment drug test in itself should not typically take very long if the applicant goes to the testing site on their scheduled date and time, accomplishes the test, and it's valid. It's not
Right.
diluted or anything crazy like that. And then once we get the response back, usually we get that within 48 hours of the tests going to our MRO.
Okay.
So the turnaround
Streamlines,
time,
essentially, yeah.
the turnaround time is very small, typically
Right.
on the drug test part.
Okay.
Yeah.
Counselor Baker?
I'd like to encourage the justices, whether you table this or not, the policy, whether we pre-employment drug test everyone or just say safety sensitive, aside from that issue, whatever you guys decide, this proposed policy is, as Director Burchett stated, drafted by the AAC, who is our risk management council. So they will be our defense in these, lawsuits that come forward. So we followed their policy, and it also follows the medical marijuana rules, and it also follows drug-free workplace, just straight from the statute. So I would encourage you all to pass it, whatever amendments you put forward, because as Director Burchett stated, our policy needs to be updated to reflect 2024.
So the why pass it, like the sales pitch is because the AAC says so?
The sales pitch is that currently, the county has no policy on medical marijuana, and the drug-free workplace policy was outdated and incomplete. So it must be updated to protect us legally, whether we pre-employment drug test or not.
Okay, that's all I have, thanks.
Justice Dennis?
I just want to bring it to attention that a table is not debatable, and you're to cease all discussion and vote on the table at that time.
You're correct. A motion to table would not be debatable, but that is an event where you put something down now, take up other action, and bring it back up in this meeting. The motion that was made was technically a motion to postpone to a certain time, and that is debatable.
And I guess that's subject to the chair. I thought we were having a great conversation. I hated to cut that off I'm here to try to facilitate the discussion of you guys. I would hate to cut that off just for a postponement, but Justice Lyons?
I agree. I don't have an issue with the policy as a whole. I think the pre-employment is the thing to consider. A cost of not testing pre-employment, I think, and it's a question for you to confirm or deny, or tell me I'm wrong, sorry. You hire somebody, no pre-employment, 3 months down the road, you have reasonable suspicion, you test them, they test positive, you fire them. Mm-hmm. You've lost costs to hire them, that whole process, train them, get them into the job, and you got to start all over. So there is a cost to not doing that. Again, the data, which I understand why you wouldn't want to make it public, but be curious as to how that fits in that data. Maybe the data doesn't prove that that's worthwhile. Don't know.
Was that a question? I'm sorry. I thought that was a statement.
Would you agree with that cost, that is a cost to not doing?
Oh, to not doing it. Oh, yes, it compounds the cost, because you're correct. There is an admin cost to onboarding somebody. There's an admin cost to the background, or there's an admin cost to the background check as well, because we're contracted with a company who has their own admin costs that we're being charged for, aside from the actual cost to all the places they have to check. So yes, you're correct in that statement.
Counselor Baker, why don't you just leave your mic queued up? Leave your mic queued. There you go.
I have spoken with the sheriff's office, and I've worked with Sam Martin, their legal counsel, extensively on this policy. And he had concerns that are addressed here in the proposed policy. But I can share that he shared with me that they have never had a positive drug test over there. And I know most of those guys carry guns, so they know better. But there are lots of receptionists and clerks and all kinds of people who might not be, technically safety sensitive. They've never had a positive drug test, and in their post-accident testing, they've also not had a positive drug test.
Justice Hires?
Thank you, Judge. I wanted to explain why I asked the question. It's because I had just recently read this study that in 2017, states spent more than $490,000 to drug test 2,551 people and yielded 300 positive results for the $500,000. And that's why I asked the question. So just because I had just read this study. So that's why I thought it was relevant. Thank you.
Great discussion. We have a motion on the floor to postpone until the next County Services Committee by Justice Simons, a second by Justice Dennis. All those in favor? Those opposed? That will be postponed until the next County Services Committee meeting. All right. With that, we're going to move on to item number 7, introduction and discussion of regulations, standards, and specifications for the division, development, and improvements of unincorporated land in Washington County, Arkansas. I want to kind of tee this up. I sent out you guys an email with this draft attached to it. This is hopefully what's going to start a long conversation here of something that's really critical for Washington County and our growth here over the next few years. What I want to say is this has benefits not only where we decide to go, but talking with Councilor Lester, our current planning and zoning, the CUP process is now incorporated in 70-plus ordinances. And so whatever we decide to do, we need to get that consolidated down. This ordinance would do that as it's written now, is that this would be the one stop, if you will, for our planning process, and we would repeal all those other ordinances. I just want to say that this is an incredible effort to strike a balance here, and I think everybody on this horseshoe would maybe have a different definition of where that balance is. I've gotten some feedback from citizens about this, and I think this can be a very emotional subject for a lot of people, and I can very much understand that. I've been through these as both a justice of the peace and a citizen, and so I want us to put a lot of work and effort into this. What I hope everybody can agree on is that our current process has just morphed into something that is, in my mind, completely onerous on everybody involved. I think it many times can be a very much overreach of our government in terms of what we're trying to dictate to our citizens. And I want us to all understand also that our reputation precedes us with our CUP process. And what I mean by that is we are hearing from everyone, I think. I have a hard time sometimes questioning whether or not we're advancing the ball from Washington County. I think we all live that, where we're angering the citizenry, we're stifling economic growth. In my mind, we have what is the lose-lose situation many times when we take up these particular issues. And so I want us to have all that in the background. One of the things I've heard from people is, they can't believe that we as Washington County would consider implementing planning and zoning within our unincorporated parts of the county. And my first feedback to them is we have it, and it's horrible. We have it in what we're doing right now. We already have planning and zoning. So my message to you guys is we have to do something. We certainly cannot continue to do what I think is high-centered right now. Some of the benefits of this new plan that I think this comes with, and what I want us to start with, is I think this enhances property rights for everybody in terms of it gives us now a way to communicate where we would like to see growth go. And I think about this from both the developer or the business owner, if that's what you want to call them, the applicant, if you will, and the citizen. If I have land as a private citizen and I would like to sell that land and get the highest and best use out of it, I have no way to communicate right now what can be done with that land. They're in the same boat as the applicant, and that is this completely subjective process to where they have to search out and purchase land somewhere in the county, come up with plans, go through the planning process, and hope on the other end that they can get something out of that. And I think that's very problematic. We're not giving anybody any certainty within this. I think this facilitates a lot of responsible growth for our county, makes the planning process much more proactive than reactive. Right now, I believe that we're only playing defense in a lot of ways. I think the word zoning comes with a lot of maybe negative connotations with it, but what I want us to focus on is planning. This allows everyone to plan. This allows the private landowner to plan. This allows businesses to plan, and so this is a way that I would like for us to move forward. With that, I'm just going to turn this over to Councilor Lester and Director Ada tonight. They put a lot of effort into this. I want to thank them so much. We've been talking about bringing this forward for several months. That delay was not due to lack of effort. It's due to just how complex this is. And so I'll let them go over this evening, and then we want to give you guys the opportunity to ask questions and have a conversation about this as we move forward. So with that, Councilor Lester.
Thank you, Judge. Appreciate the opportunity tonight to come and talk about this. Like Judge said, this is certainly something that, as far as administratively speaking, this has been in the works for years. This is something that I think there's been a lot of discussion about. And I want to let you know that we put this out tonight not as an ordinance. And the reason we did not put this out to you as an ordinance is it was not our intent to speed through this process by any means. We want to make sure that you have time to look at this, to ask questions, to fully understand what it is that the county's looking to do and make sure you understand it before we move forward. And so I say that so that you will know that there's no hurry, there's no rush. And you may have questions tonight that Director and I may need to get back with you on to answer. But I'll tell you ultimately the gist of it is we have kept the planning code for the most part is exactly identical to what it was. What we have done is we have changed by adding a zoning section to that. The courts have told us over the years of appeals that while we call it conditional use permits, it is in essence zoning is what we're doing. It's a legislative act. There's a lot of ramifications that come to that, but legally speaking, a legislative act is something that you, as the legislative body, ultimately controls. And unless you act in a way that is arbitrary, capricious, or unreasonable, the courts will not get involved and interfere. They don't sit as the quorum court when they look at those actions to see whether or not they might have done the same thing, but instead they look to see whether or not you acted in a way that was arbitrary and capricious. And what we have now with our conditional use permits, we are starting to really get up to that arbitrary and capricious line in a lot of instances. And so what we hope to accomplish with this would be something that would allow us to refrain from getting that close, to make this more of a solid legislative act, and allow you and the citizens that come in, one, to see what's going on and to protect those property owners like the judge said. What we have tonight, this part of it is just one half of what we have to do. The other half of this is we will have to vote on and adopt a zoning map. And so as we talk about this, let me tell you what we see and what the cities and other jurisdictions do when they talk about zoning. The purpose of zoning, certainly the purpose for Washington County, will be that we are directing commercial businesses to a particular place where other commercial businesses are. We are diverting them from out in the middle of nowhere in the county where there's nothing but agriculture and residential homes, and we are diverting them to a place that is more geared and suited for commercial businesses. Historically, those places are going to be on the corridors, the highway corridors that go through the county. In doing so, there's going to be a lot of people that probably are not going to be happy with the zoning maps that we look at, because people that are currently just have farms out on some of these lands are going to be looked to a change to commercial zoning. There's no requirement that those people do anything different, certainly. But we know that is where we want to drive the businesses and away from the other rural parts of the county, more rural parts of the county. If anything, it's going to help property values for those property owners should they ever decide to sell their property. Their value, because of its zoning, is going to be worth more than it is now. those are things you'll have to consider. Those are things your constituents are going to bring to you, but I tell you that just to give you a heads up. We're not here to talk about that. We don't have a map or proposed map ready to go for you yet, because we didn't want to throw all of that at you at this time. And so I just really want to kind of hit the high points on what we have here and kind of where some of those changes are in what we've done. To give you a little bit of background, the actual first kind of planning ordinance that the county passed was in 1978. It was updated in 1980. It was updated again in 1991 and updated again in 1995. And so in between those, there have been a lot of different updates that have come along that have changed and updated that county policy. And then, as you know, in 2006 was the year that we actually went to zoning, where we zoned everything in the county, single-family residential, agricultural. Anything that is not single-family residential or agricultural is a non-conforming use, and that is what you now issue conditional use permits for and consider those on a case-by-case basis. But there is no area to try to force or to try to direct that growth, that commercial growth in the county. We are going to grow. The county is going to grow. If you look at historical data, you know, that's all we've ever done, and it's going to continue to happen, that we're going to continue to grow. And so this is something that we've got to kind of get our heads around in order to move forward, and this is one way that we think will be more beneficial to everyone involved. And so, just to get started, the first part of this are definitions. We added definitions that were found like sporadically throughout the code. We tried to get a lot of those that applied to all of the code in several different sections. We tried to get those into the definition area. Not a lot of fun, not a lot there to look at, to be real honest with you. The first big change that we have comes on what I have as page 10, and I'll tell you, this is a working document. It will continue to be after tonight's meeting as you have questions or things are brought to our attention that may need to change or that we may need to look at. And so it's just one of those things, so please understand that this is why it's also not an ordinance, is because we're not going to have to do a lot to amend this because we don't have it. Once we get to that point, we'll put it in ordinance form, then amendments start everything back over. So we want to kind of have some time to do that. But on page 10, under section 4, the land development in the unincorporated areas of Washington County, there is a subsection, or section 5A little I. And it says it is the intent of the county that development and improvement of land within the unincorporated area of the county, but within the territorial jurisdiction of any municipality, shall be developed to the standards and regulations approved by the municipality when requested by said municipality. State law says right now, territorial jurisdiction area is the term the state law uses, what we commonly refer to as future growth area. Depending on the size of the city, depends on how far out from the city limits your future growth area or territorial jurisdiction is. As it stands now, the cities have exclusive jurisdiction over subdivisions within that territorial jurisdiction area, which means when someone comes in and they're in the county but they're in the city limits of Fayetteville or Springdale or Elkins or Farmington, we send that to the cities, just the subdivision itself. They have control over everything in the subdivision. We have to defer to them. That's state law. What this does is this takes it a little bit of a step further. And because we're not undoing that, we don't want to undo that. We want to actually give the cities the ability to have a little bit more control in their territorial jurisdiction area if they want to. Now, if they don't want to, they don't have to. But if they want to, and a lot of the bigger cities, I know Fayetteville and Springdale would probably benefit a lot from this. We have a minimum lot size of 1 acre, for example. The cities have a minimum lot size of much less than 1 acre because that's what they have to have for their growth. We don't have to have that for our growth, but for them, they've got to utilize that space. We have had numerous issues over the years where we have someone that's wanting to subdivide land in a territorial jurisdiction area of a city, and they're wanting to do so at less than 1 acre because the likelihood of them getting annexed into the city is great, and they want to kind of conform to that. Well, we can't allow that. And we have no mechanism to allow that at this point without giving them some sort of, granting them a variance of sorts, to say the least, that you then have to approve. And it becomes an issue. So what we wanted to do is we wanted to give the cities that ability to say, hey, if you want us to look at your minimum lot standard within your growth area, we'll be happy to do that. We'll enforce that, and that'll be part of our rules. And so I know, JP Rios Stafford, you asked that question, I saw it, and the reason I didn't get back is because I thought that was probably a pretty valid question that people would want to know, and that's what we're doing. We're trying to afford that to the cities that want to do that. We have Winslow, for example, they have no planning. They have none whatsoever, so they don't have anything, so they're not a city that will utilize that. But any of the other cities that have actual planning and zoning, they may want to utilize that, and it'll be completely up to them. They can tell us they want to do it. They can take it back at any time. They can re-up with a new mayor. We don't want to limit them in any form or fashion. We want them to be able to direct that, and we want to be a good neighbor and help them do that. And so that's what we've added here to kind of give them that option to opt in. There are there are some other changes we've made. As you know, the county moved away from having an official certified county fire marshal, and I say certified, I don't know how certified the county fire marshal was. That was a decision made by the previous judge and the previous sheriff, who felt like that had become more of a burden than it was a benefit to the county. And so we've gone in and changed some of the language where we had county fire marshal approval to the fire jurisdiction, the fire chief or the local fire jurisdiction. Those are the individuals that have to show up to fight these fires. Those are the ones that need to be making the decisions on the capacity and capability of their volunteers or full-time members to show up and do those things. And so we want to empower those local fire districts to have that authority to look at these things and to say, yes, we can do this, or, you know what, we don't have the ability to have that, so what we're going to need is something else. They sit in the best position to do that, and we invite them to participate in this process with us as well. Like I said, the big thing, if you get over to page 14, this is under the section that's the approval procedures. And the big change we have here is our zoning action. That's going to be the first thing that anybody does when they come and they're wanting, once we approve this, if we approve this, that would be the first step. They would come in, they would get with the planning director, Director Atta here, or his successors, whoever it may be, and we would look to see what the zoning is in. I'm not getting rid of you that quick. I'm just saying.
It's not that fast.
We may not have an issue for 30 years. You don't know. They would look to see what the zoning is. And we'll get back and we'll talk about zoning. You can kind of see what's compatible, what's not, and how we look at that. But that's going to be the first thing they do. And when the planning team determines that the zoning is not correct, then Director Atta, his team will let them know that they're going to have to request a zoning change from the quorum court. That will come to you. They will come in a rough draft, kind of say, you know what, we're wanting to open such and such. Planning team's going to say, we've determined that's commercial 1, commercial 2, industrial, whatever it may be, and it will need a zoning change. And then this body, in its legislative capacity, will look at that. You'll look at where it is on the map, where it is in relation to other so similarly zoned properties, and you'll have to make a determination as to whether or not it's feasible to rezone it. We'll start talking a lot, should we pass this, about spot zoning, so that we will, the legal team will be advising you on the dangers of spot zoning. It really is just another avenue to help you say, even if I may like this and want to do it, we can't put this big commercial property right out here in the middle of a residential area, because the courts may then say, hey, that's arbitrary and capricious. You have nothing around you. But again, it helps filter, and these developers that are coming in know that, hey, it's going to be hard if you're wanting to do that. It may not happen. You really need to look into these zones that we've already zoned. And so that's the first thing that'll happen, is they'll come in, we'll do the same neighbor notifications. As you can see, we have made a change there, something we should have changed, or it never should have gotten to this, which is the developer will be responsible for sending out those neighbor notifications. They'll be responsible for showing to the quorum court or the planning board or whoever it is that they sent those out, that they sent them certified, and here's who they sent them to. What the planning team will be responsible for is they will assist the developer, or the applicant, we can call it, to say, hey, here is a map. We have put everybody within whatever that range is, whether it's 300 feet, 500 feet, whatever that may be. We've circled all these properties. Here's the name of the property owners and the addresses that we have on file with the county. This is who you have to send your notification to. There's a lot of time spent by our planning team, which is not a large team. It's about 4 people, 3 people. And they're having to send out these neighbor notifications for all of these projects that come out. If you can imagine, that is a considerable amount of county resources that are spent stuffing envelopes and putting stamps on envelopes and sending things out. We're going to put that back on the applicant. That's something they should take care of. We do it. We have to get them to reimburse us. Not that we're out making money, but a lot of times it takes a lot of times and a lot of prodding. Say, hey, by the way, you still owe us $1,500 because that's what the county's out. We want them to do that. So we're going to put that back on the applicant and make that be their responsibility. It'll still be the same. They will still have to do the same notifications that we've done. They'll still have to prove that they've done those notifications, but that's on them, not on our team. So we're freeing up some time for our team to do more of what they need to do with this.
We have lots of issues with applicants. Sometimes, like, the halfway through the process, they decide, like, you know what, like, I decided not to move forward, and we already sent out everything. And that came out of our budget, and this is like, I'm not gonna reimburse you. And to go through the legal process just to get about like $100 or so is gonna cost more. So we are the only maybe county in the state of Arkansas that we are like taking initiative to send notification out. Most of the cities or like the counties, they do it like they ask the applicant, and that's part of the application. There is an affidavit there that says like you're responsible, and this is how the form should work, and they should sign on it and agree to it in advance.
Moving on, the fees that we charge for planning will be housed with the planning department. It will not be part of this ordinance. That'll make it easier to update as time goes on. We'll update a fee schedule instead of having to re-update the planning ordinance altogether. Another thing is there were a lot of references to the Washington County Health Department. The state got away from county health departments a long time ago. We don't have a Washington County Health Department. It's all the Arkansas Department of Health. So we've made some changes there. We used to have what's called a public utility coordinator. I won't go into a lot of detail on that, but that's not something that the county has utilized in a very long time or a need for. So we've gotten rid of that, and we've kind of made anything that public utility coordinator would have historically needed to do, we've now given back to our planning director, or what we call a planning administrator. And that's a big thing, because the planning administrator may not be the planning director. As the county grows, there may be someone designated as that. The de facto administrator is the planning director, but should the county judge need to deem someone a planning administrator just to administer all these, that can be done at a later time. So on page 67, we get into zoning, and that's going to be the meat of the changes that we're making with this. And so that's something that I would encourage you, if you've not done, to really take a look at and to see what we've got. We have removed our CUP process as it was in how we had it, and we've replaced it with this zoning because it also encompasses conditional use permits, because we still will be issuing conditional use, or you will be issuing and approving conditional use permits, but they are going to look a lot different. Because the majority of what we have that comes through the quorum court would really be classified as a rezoning and not a conditional use. As you look through the zoning provisions, there's a lot about the enforcement and administration. It talks about the zoning board of adjustments, which is the same as the planning board. They're the same members. They just sit as 2 different boards, which is allowed under state law, which is what we've always done. And then if you look over to page 73, we get into the district regulations. So we have the agricultural residential, which is what we've always had out in the county. That will not change. But what we also have, we've accounted for a C1, which is a light commercial, and a C2, which is a general commercial, and then an I, which is an industrial. And those are the classifications that we will have out in the county for various parcels of property based on what's going on. And as you read through there, you will see kind of what those things are. So under agricultural residential, under permitted uses, agricultural uses, single-family dwellings, which is currently what we have, manufactured homes, churches, daycare family homes, those are all permitted uses. People will not have to come in and get CUPs for any of those in those areas. That's allowed by right. It goes on to talk about a conditional use for an agricultural residential will be a cemetery. If someone wants to come in and utilize the cemetery, they can do so. It's conditional. The quorum court would have to approve of that. It goes on for light commercial, general commercial, industrial. You can see all of that and kind of, get those classifications for what's going on. And if you go to page 77, it's the beginning of the use table. This table here is what the quorum court's really going to use. It's really our matrix that we'll start using to see what can happen in a certain piece of property and what can't. And so anything where it says P, that's a permitted use. So single family is permitted in a commercial 1 or a commercial 2. So we won't be kicking anybody out. And by default, agricultural as well, we can always put that in to clarify it. Those are going to be permitted uses because we're not trying to change any of that, but we are trying to direct. And then anything with a P or a C is going to be a conditional use. And so you can see like a car wash in a commercial 1 is a conditional use. We don't have a lot of, or any that I'm aware of, car washes in the county, but that would be a conditional use. It'd be permitted in a C2 or in an industrial. And so this matrix is really what's going to help you see and visualize and know what can happen and what can't happen. And so anywhere that, this list, I know as time goes on, will have to be updated. And those are just kind of one of those things that we'll just have to look at and may need to update from time to time. But this also helps individuals, businesses that are coming to Washington County that are looking to see what they can do, what they can't do, what they're going to have to ask permission for, and what they're not going to need permission for. Conditional uses, as you can see on starts on page 79. It goes through, this process goes through on page 80 towards the top. We have a list of conditions for our conditional uses. That you all will look to as because those are the things that have to be met. They're proposed uses within the provisions of a conditional use. It conforms to the applicable provisions set out herein for the district in which it's located, is so designated, located, and proposed to be operated that the public health, safety, and welfare will be protected. So just like you have now, you'll have the same kind of list of criteria to consider. Much more objective, much less subjective, which I think helps out, for me, when I go to court, these things make a big difference what we're doing. And so, as you can see, this is all laid out in pretty good detail. Once we get past the zoning or a conditional use, then what happens after that? It all becomes in-house administrative with our planning team. They're the ones that will go over the technical reviews. They're the ones that will make sure that the applicants are complying with the provisions that are set out herein, along with our road department, along with the sheriff's office, along with the Department of Health, the same things that are happening. And so those are things that that team will then take the project to the next level. One of the benefits that I've seen from, or the thought that I've had about this, there are some horror stories of some applicants that have come through. And I remember particular applicants that came through several years ago. I felt really bad for them. They came in, they wanted to get a conditional use permit. They'd done a lot of work. They'd spent $70,000, $80,000, this older couple that was retired, for this facility that they were wanting to put in for youth. And they got to the end and it was ultimately denied, which was well within the quorum court's right. And the reason I felt bad for them is I heard them say afterwards that they had spent their entire savings on this project and they didn't even have the money to appeal it. Unfortunately, that happens a lot. The process we have now often requires people to spend $50,000, $75,000, $100,000 just to get here in front of you to say, can I do this? And then you have a lot of considerations that you have to make and look at in doing that. I am hopeful that this project prevents that people can come in with an idea, and before they spend $20,000, $30,000, $40,000. They can be told, yes, you can do this project here. No, you can't. You need to find a different piece of property. I think that's fair to them. I think that's only fair to the residents, to the taxpayers of the county. It also says to the taxpayers that the people that come in, and we hear it all the time, I moved to the rural part of the county because I wanted to get away from the city, and now this person's wanting to put something in right across the street. This code change that we're doing is going to help protect those people who moved out to the county to be rural, to be less urbanized, because it's going to allow you to say, yeah, you can't just put something like this out in the middle of nowhere. You need to go. Here are the places. We have places. We welcome you to come. We work well with people, but please come and do it in these areas. This is what we're directing. We are protecting these people. I think all in all, it becomes a much more palatable thing for those developers, those applicants that come in. I won't bore you with all the different things because all of you can read, and I want you to take the time. I know you got this last week. I don't know that I would never say that was long enough to take for the first bite to look at this. It wouldn't be for me. I've been working on this for months and months and months, and there's still things that catch my attention every now and then from doing this that we forget about. The flood damage prevention that's found on Section 6 is, I don't know if y'all remember, but several months ago, we passed a new flood damage prevention code, and this basically incorporates that word for word. So there's not a lot to do there. And then finally, at the end, we have our placement of antennas and communication towers, which we get a lot of requests from. We've cleaned up some language there. There was some confusion. We've had a lot of people say, or a lot of big cell tower companies say, oh, all we have to do is administrative review. And we have to remind them, no. You still have to do the CUP part. You don't just get to come in and put a cell tower wherever you want. You have to come ask permission because that's not residential, single-family residential agricultural. So we've kind of made that more clear in this so that is not an issue for them. Finally, what we've done is, and I thank Director Ada and his team for getting all this, but the exhibits, our drawings from our engineers are updated. If you had seen any of the old ones, you could not read them anymore. They had been photocopied so many times that they were blurry. They were the same ones that were done back in the early 80s. And so with that, we have this is all digital now, whereas what we had in the past was not digital. We have all this digital, so it's a lot easier to reproduce and give to somebody. They can see, an engineer can see exactly what our road standards are and understand all that's going on. One section that I'll point, I will say that our hazardous material, we had an ordinance, it referenced an ordinance from back in the 90s that you could barely read, and I guarantee that all those standards have changed numerous times. So we took that out and we said, hey, here are the things, here are the different places you can find what hazardous material is. It's all spelled out by the federal government, which is what we were in essence doing. When you list those things out, if you don't go in yearly and update those, then you get way behind on what's going on. So instead of doing that, we just said, hey, these are the places that you look for hazardous materials. This is what we consider a hazardous material. Go to their website because they keep those things updated. Therefore, we as a quorum court don't have to constantly go in and look at that. Those are just some of the things that we tried to update to put this, anew, put it fresh in front of us. I do think that we will be able, and I've personally gone through on at least over 75, like the judge said, over 75 ordinances to make sure that every provision of those ordinances are included in here, that we're not missing. Like, in other words, if we do this, we're going to end up replacing 75 plus ordinances, but I wanted to make sure that I could personally come before you and say I've looked and read each one of these ordinances, cross-referenced where they are in here to ensure that we're not going to leave something out that had been passed previously that we didn't intend to update or anything like that. So I know that's a lot. With that, I will be happy to try to take, and Director Ada and I to try to answer as many questions as you may have.
Yes, I welcome that. I would be remiss if I didn't say I want to thank Jeff Hawkins with the Regional Planning Commission. He put a lot of labor into this too over several years, and so hopefully we're getting. I really appreciated his guidance and, of course, all of his expertise in this, and I just want to make that known tonight. With that, Justice Taylor.
Thank you, Judge. And I wanted to start by saying, I recognize the ambitious undertaking that this is from the executive branch to put this forth and really am excited about digging into it. And I mean, it's a lot, so kudos on that. But secondly, and if I've missed this somewhere, forgive me, but would you point me, Counselor, to, like, is there an example of where somewhere locally or maybe nationwide where, you know, something very similar to this was implemented that we could kind of see as how it has functioned so far? Or is there any one, you know, everybody knows being a lawyer is just copying other people's stuff, right? So where did this get copied from is my question.
So the zoning part that was brought in was actually created for us specifically by Jeff Hawkins with regional planning.
So it's not modeled after any particular...
It may be, but it's what we asked him for his help while right towards the end of his tenure with regional planning. Jeff Hawkins had been around and has done a lot for planning in Northwest Arkansas with regional planning. He helped back in 2006 when the original zoning ordinances. He had a lot of thoughts and a lot of things. And given you know, he's the professional. I certainly am not when it comes to zoning and planning. And because he lives here and because he has seen what's gone on and he has watched what's happened in Washington County, and we've asked him for help before, he has been able to craft something that is very tailor-made to what we do.
Okay.
And so we, you know, J.P. Coleman, you know this, we, as an attorney, we often leave that up to I often say that to courts, you know, we leave that up to the professionals. You wouldn't, you know, you wouldn't want me going in and diagnosing your heart arrhythmia because I don't know anything about it. I'm going to get it wrong, right? So we leave that up to the professionals, and so this is something we left up to him. We took a look at it. There were maybe some slight modifications. Typically, it's with terminology and whatnot to fit kind of what we have. But those were about the only things we did. This is something that he tailored just to us.
Okay.
I'd add to, I just want to jump in here.
Yeah.
We are very unique from a county standpoint in the state of Arkansas that we've even went down this path.
Yeah.
I mean, we're very unique in that.
Mm-hmm.
You know, I think I've talked to some of our counterparts here. I've talked to people on this horseshoe. I think there's a lot of us that kind of regret that. But now we're trying to maybe fix, and I'm not saying the CUP didn't serve us well for a number of years,
Yeah.
but it's definitely become aged. It's definitely become antiquated.
Yeah. And I mean, I would add to that, you know, I deal with real estate in different counties around the state, and, you know, it varies, right? But we are unique, I can tell you that, in how we treat, you know, property in the county versus in city limits. And so, you know, everybody I think can agree that the current situation has it's run its course, right? Like, we're over that now. Where do we go from there is really the question. And so I'm tired of sitting here, honestly, but I won't keep you. But last question I have, like, realistically, what's our timeline, you know, as far as how do you see this progressing from a calendar standpoint?
Well, that's really going to be up to the quorum court. Like I said, this is not in an ordinance form. We still have to also approve a zoning map. So it'll have to go to a committee and pass out a committee. Both of those items will have to pass out of this committee onto the full quorum court, where it will go. And absent, you know, a vote otherwise by the quorum court, it'll go through 3 readings. And so, you know, we're probably looking at a 3 to 4 month, once we get to the ordinance part of this, 3 to 4 months, you know, before we pass and implement something.
Would we, in your opinion, or in a perfect world, would we do both sections or both tranches of it together, or would it be like bifurcated?
No, I would encourage you and advise you to do it together so that they pass and are effective at the same time. Because if you pass a zoning map without zoning,
it leaves you in between.
You have, yes, or vice versa. You're going to have problems. So yes, they need to be done together.
Okay. And I mean, are you, like, is this your full-time project? I mean, this is a lot. Like,
this is definitely something that we have placed on as a priority, priority 1 for us. Absent the things that come up that have to be taken care of and the timelines, this is definitely something that Director Anada and I have spent a lot of time looking at and tweaking and working. And I mean, up until today, looking at things. I mean, we're going to find some little tweaks and errors here and there. Nothing major. A lot of them were just Scrivener. I think Director Ada found, you know, we had a lot of code. The quorum court had gotten into the habit of amending the codified code. And so just to kind of give you guys an understanding of our codified code, The law requires that we codify our ordinances for ease of people to come in and look at. But our codified code is not the official code of the county. Those ordinances are what's official.
Right.
We had gotten into the habit over the years, going back a ways with my predecessors, of actually amending codified code. When we sent our code to be codified by the AAC now, because it's a service that they provide to us that we pay for, instead of paying a separate company to do that for us, this part of the code they could not codify. And the reason for that is because our ordinance amended codified code, and there's no such thing. The state law says that that it takes an ordinance to amend an ordinance. So we can't amend the codified code. So that's one reason we're shoring this up, And we had to take a lot of those references to the old codified code sections and put them back out in here. And so you'll see like Section 5, subsection A, little I, A, little b, or little 4 or something, Roman numeral 4. That's all so that once we get this and we send this on to AAC, they can then codify this for us.
So it reads as one law, effectively.
Yes, and it's easier, and we can look through, and that's what we have for people to look through. So we're trying to kind of two birds with one stone here to kind of get that updated.
Great.
So if you look at some of our applications online, they're all available. You will see as section 1-1990 something, and they're article 1 to 4, and then 1970 something -1 article. So you have about 6, 7 codes, ordinances that reflects on just one paragraph.
It's piecemealed, in other words.
Yes, and that's what the confusion comes. Says hey, which section I'm under? So
all of them.
Yes, all of them. Yeah, and then we go back. So it's agricultural use or residential and CUP.
So who do y'all see as being maybe not the most impacted, because everyone's going to be impacted, but I mean, if you were to guess, knowing what you know right now, where are the pressure points in this as it stands today? From a general public.
From what you're going to have to pass, from what I think the public's going to have
where's
the biggest
the
concern
pushback
with.
going to
The
come from,
pushback,
you
I think the pushback's going to come with the zoning map, and here's why. We're going to have to go out, and fortunately this is already done, but we're going to have to go out. You have projects that have already been, a conditional use has already been approved. I mean, the law is clear that you can't undo those. I mean, the courts have made it clear. You cannot come back in and say, okay, we changed our code, so now we wipe all of you out. You can't operate your business.
So those would be grandfathered.
Those would be grandfathered in. So those are places where we're going to have to review as to what they are based on their conditional use permit. But I think the real pushback is going to be at looking at those corridors. You're going to get a lot of property owners on highway. Think about Highway 412 between Springdale, between the river, the river, and Madison County. It's all, for the most part, farmland, with a few exceptions. In order to do this right, you've got to have a place to direct commercial businesses. So you're going to have to look to those corridors for possible rezoning to commercial. And you're going to have a lot of people that aren't going to like that. And I get that. Trust me.
Yeah, the line has to stop somewhere.
You're going to have issues. There's no perfect way to do this. We're out there. We've already been doing this. We're going to have to make some really tough decisions on what those things are. I can tell you that I think that it's probably going to end up being more of a benefit to those individuals when they get ready to sell. Mm-hmm. They don't have to sell. A lot of people, farms pass on, but as we know, that farms are becoming more and more scarce as time goes on anywhere. People come in, they buy chunks, they break up family farms. If I'm a farm, and I have 2 farms on either side of me on 412, and I just stay agricultural farmland and I want to sell my 40 acres, I'm going to get what a 40-acre unimproved farm's going to get on the market. If I'm commercial and I want to sell that, I'm going to be able to break those 40 acres up, and I'm going to be able to sell those things for a lot more money, those parcels a lot more money, because of the potential that they have for that business. There's going to be a trade-off, but it's going to be hard.
But I guess my question is more to the effect of what is the plan to accommodate more single-family existing usages? Because to me, that's who's going to complain. That's who's going to have the biggest sort of impact from a rezoning if they're close to one of those boundaries, right? So how are we going to address that, you think? Just kind of whoever shows up?
That's a hard one. because as we continue to grow, these boundaries will grow, these zones will grow, things are going to happen, and that's just one of those things that you know, we can speculate on the future. I think we're doing a disservice to everybody when we start speculating. Even when you guys hear CUPs and people say, "Well, I just know that in 10 years." We can sit up here and talk about what's going to happen in 10 years to somebody's property. In 10 years, somebody could find a huge stash of oil under my property, and I'm going to tell you, I'm going to sell real fast when they do that. I don't care about anybody's property rights after that, right? Yeah. Those are the things that we probably should steer clear of. Now, there are some ways to go and protect some of those areas where we already have CUPs. You can look at not rezoning those, continuing those as just conditional uses. But they're allowed to continue that use until the use changes.
Do we have a map of those?
Yes, we do,
Okay.
and we'll get all that out. Those are the things that you'll have to consider, and what we'll really, be arguing about, talking about. But ultimately, we're going to have to pass a map and say, look, this is what it is. What it is. I mean, we can look at it one way and say, hey, it is what it is, because it really is. And we're just gonna make a decision, and this is what's going to happen. I say all the time, I had a band director in 8th grade. I used to say all the time, you can please some of the people some of the time, but you can't please all the people all the time, and that's just the fact of it. As we look at this, that's what's going to happen, and it is.
Yeah, I mean, this is the life cycle, right?
That's right.
There's going to be some temporary pain now for being able to live with this for X number of decades until we evolve again to where this particular setup is no longer viable. That's not our problem today. We all admit the existing system is broken. Is this how we fix it? And if so, how long do we sell people on the fact that this is going to fix it? So what does it cost in the interim as far as the pain points? And that's what we'll have to be ready to address.
That's your problem, not
Yeah,
mine.
no, it definitely is.
Well, and I would just jump in and say, we have those same pain points in what we're doing now.
Oh, for
That's
sure.
a
They're
sunk
just
cost to
different.
me. That's a push, right?
Yeah.
I mean, I think our only other option is let's get out of zoning.
And do nothing.
Are we ready for that? I mean, is that what we can have that ordinance drafted up very quickly if that's
true.
if that's the consensus of the body. We've tried to listen from instruction from you guys, and that's why we've gotten you this starting point, because we figured this is the way we wanted to move.
I'm excited for it, so that's it.
Justice Fleming?
Thank you, Judge. Brian, do you foresee more regulations on the zoning out into Washington County?
More regulations as far as
Anything that, I guess when a farmer wants to build a big shop building, is it still going to be able to build a big shop?
they are. Those will be exempted from this. And there's language in here. It talks about agricultural buildings, buildings like that are specifically exempted from the regulations in this. We're not going to change any of that. We're not going to make it any more difficult for a farmer or for a landowner that lives out in the county. It will not be more difficult
So
for
a
them.
residential area in the county, say a mile from the city limits of Lincoln or Prairie Grove, wants to build 6 chicken houses, they can continue on just like they are today.
That's exactly right.
Yep.
There will be no regulation. And if I guess maybe not with Lincoln, but you got to also understand that in some of our areas that we're having these issues, they're within the future growth area of a city. That city could grab that land up as soon as you say yay or nay to a conditional use permit and completely change what's going on.
Well, Lincoln used to have a 5-mile area, and they moved it back to 2 miles.
Right,
They
right.
come back.
But no, as far as the agriculture and the residential and all, we're not changing or doing anything different for them.
So policing this is going to stay the same?
Yes, we've beefed up kind of what we're doing here, the fines, the enforcement, in making it clear that it's the enforcement arm of government is the sheriff's office of county government. I can't go out, Director Atta can't, we don't have the ability to go out and write tickets, but this is going to make it a lot more, we're going to make sure this is easier for them to help police this when they get a phone call or we say, hey, this is going on, and it's not a question. Hey, I go out, we write a ticket. Here's what we can do to try to keep people in compliance with this before we get to a point where we have to then get into some sort of litigation. Because as you know, and this is something we can look at changing, but when an appeal of something is filed, we cease the ability to enforce and issue fines. That was passed by the Quorum Court back in 2007. And so that's an issue that we have now. You know, we get a lot of calls on that, but we are limited by our own rules that when an appeal is filed, we're done. We have to let the courts take that, and as you know, that's a lengthy process.
Yeah. Back to the fire marshal side of it, I was a fire chief for 18 years, and I had plenty to do besides come to planning meetings, and had plenty to do to come and take on fighting an issue out in the rural areas.
Mm-hmm.
I don't think in another 20 years you're going to hear the words volunteer fire departments, but these little towns can't afford paid people. But I think the fire marshal needs to be relooked at and rethought, because I believe the time of day we're in today, I believe it's time to have a fire marshal, a true fire marshal in Washington County. I believe that, but I may be wrong. I don't believe we need to put this pressure on top of volunteer fire chiefs out in the rural areas that's already overwhelmed, that's already volunteering their time, to ask them to go sit in a lot of these meetings and a lot of this stuff. So
that's not what we ask. We simply say, here's a project. Is there anything that you would need? Is there anything we need to add to this to make this easier for you, or you know, what can we do? Do you have the capacity to respond to a fire out here? That's really all we ask.
Well, I mean,
and if
that's a simple question, and that's true, but we've got one going on now, and Sam knows what I'm talking about, that we've been fighting for how long, and we're still fighting, and it's going to wind up in court, and if the volunteer chief has to go testify and do all this stuff in court against all that, I mean, that's a lot more time.
Well, I understand. We also have a state fire marshal, and that's their job. And there are very few counties, if any, that have a county fire marshal. It's very rare. We're not getting help out of there. That is not something I believe that should fall back on the county just because the streets are paved with gold in Washington County. The state fire code is the law of the land. And so that is, you know, this is one of those things that we can talk about and argue and speculate for forever on. Sure, in a perfect world, absolutely, that'd be great. There's a lot that goes into those fire marshals, a lot of training that they have to do that we've not been able to keep up with as a county in the past when we've had a fire marshal adequately to do the job right. And there's a lot of responsibility and risk that come along with that too. And so my point is, we want to make sure that what projects are going on out here, that the local fire jurisdiction has had the opportunity to weigh in, that they are heard. That's what we want.
Well,
and that we can be good neighbors with them and help them in any way that they need. I was a volunteer fireman for a long time. I know, you know, and so sometimes they say, yeah, we really need something specific here to help with this. And we want to say, okay, well, then that's exactly what we'll do. But a lot of them say, hey, no, we're good. We have this, that, and the other, these apparatuses, we're good. We just want to make sure that we're not leaving them out and that they actually have a say. Because we have had issues before where the local fire district has said, we don't have a problem with this. This is fine with us. But somebody else acting as a fire marshal has said, oh, you've got to meet all these regulations. And I can tell you a horror story about a cell tower that we needed a ladder or a hook and ladder truck to get to out in the county when no one had one in 6 county area, and we were going to deny it because because there wasn't a hook and ladder truck that was 500 feet tall. We didn't have that. That was unreasonable to expect that somebody's going to be able to comply with the turning radius for something like that when that doesn't even exist, right? Correct. So we get into these issues. And I'm telling you, all of this are things that I've seen in my limited time here. And so we're just trying to be as proactive and respectful of our partners in this to do what they need.
Okay, thank you.
Justice Dennis?
Thank you, Judge. Great job.
Thank you.
I think it's really good, and thank Mr. Hawkins for that, too. At the same time, there will be a lot of questions, and you answered one of mine a little bit, but at the same time, it didn't real clarification on it. If I have 1,200 acres, own 1,200 acres, and you tell me that I have to be commercial, or you tell me that I have to be residential, I'm going to tell you, well, I'll make the decision about my 1,200 acres, not you. And so how does that work?
Well, I mean, anybody would have the right to appeal the zoning map to a court, And the argument would be whether or not the quorum court was arbitrary and capricious when they passed it. It'd be no different than what goes on now. And so I respect that and respect that argument that people have, but we're beyond that. And I wish, I'm a property rights guy. You're right. If I tell you you're commercial, it doesn't change any aspect of your 1,200 acres. It doesn't require you to do anything different. It doesn't change your property taxes. It doesn't do anything.
But reverse that. If you tell me I have to be residential and not commercial.
Well, you already are. We've already passed that. That's a done deal. Everybody in the county is residential agricultural. They're not commercial. They have to ask permission to move to a different class. We're beyond that part.
Okay, all right.
Okay? If we designate zones for commercial growth, it does not change the use and enjoyment of anybody's property as they have it now. It gives them the option of selling it commercially, whereas if I live out where I live in Elkins, away from any corridor, I don't have that option. These landowners will have the option. They don't have to change it. They can continue to farm, won't change anything that goes on in their daily life. We're not making them do anything. We're giving them that option.
It's really not clarifying it for me, but I think that clarified it for who I'm asking for. So the other one is city annexation. I lived here 20 years ago when every city was guilty of it, trying to annex as much as they could for tax money. And some went way out and, grabbed lots of land all around them, but yet they didn't provide the services with that. And also some of the boundaries don't make a lick of sense. Prairie Grove and Farmington is a good example of that. And so will we have control over that, or who?
Nope.
The city has control over the annexation?
That's exactly right. When annexations come into
will they be told in the future what they can and cannot do as far as annexing? Because we say this land is.
I'm going to tell you, for the most part, they'll annex that land in, and they'll continue that use, or they'll vote to change the use pursuant to their own policies. The county judge, all annexations come to the county judge. The county judge there's no discretion in the law to say, you know what, yep, we agree you should annex this, or yeah, we see what you're doing, you're taking some of our tax dollars. The law is clear. The county judge looks and says, has A, B, C, D, and E been met? And if so, he or she shall sign an order annexing that property. We don't have any control over that. This doesn't change any of that at all.
Okay, all right, thank you.
You're welcome.
Justice Simon?
Thank you, Chair. Thank you, Mr. Lester. I think you started hitting on this, and I wanted to make sure and get some clarification. When we're working on this, which, again, thank you for your work on this, the assessment and taxation of this land, if moved into these commercial zones, doesn't change unless they choose to go from agricultural or residential into a commercial. Then it would be assessed and taxed differently, correct?
The assessment that happens on your property is based on what the actual use of your property is. And so if it's a house, even if it's in a commercial zone, it's going to be assessed based on the value of so many other houses similar in size and stature to what you have. So your assessment's not going to change. Okay. If it's a commercial building, it's going to be assessed based on other commercial buildings around, however far that may be. I mean, that's the assessment won't change on this.
Okay.
Justice Pond?
Yes, thank you. This may seem like it's kind of getting back to something a little smaller that's been brought up, and I wanted to say I appreciate what Mr. Hawkins has done for us.
Absolutely.
But we get back to the situation where this has been something that's been needed for quite a while. When we possibly can, when we zone or we develop right outside the city limits, it's unincorporated area, maybe it's in their planning area, we try to make that, make it similar to what's inside the city.
Mm-hmm.
But when we come to a place where, you know, we allow the city to determine, say in a subdivision lot size, minimum lot size requirements, so it matches what they've already done. That could also be well and good if the city is going to provide the fire protection, the water supply, and also be accountable for some of the drainage, which the county judge that's his jurisdiction, is roads and drainage. And why I'm saying this, many times you're not going to have adequate water volume or pressure to come into a place and fight a fire where you have houses that are put closer together. When you've got like what we have, a 1 acre minimum lot size requirement, or if we're in the Goshen growth area, it's 2 acre minimum lot size requirement. It's much easier for rural fire departments to address those issues. I'm a little hesitant to think about just accommodating, say, one of the bigger cities who has all this equipment and they're doing these sort of developments, for us to say, well, okay, you decide how big these or how small these lots can be. And I know that's a very small issue to bring up when we've got the big pictures, pretty exciting, and I know we've got to make some changes, but I'm hoping that when you're writing this stuff out, you consider these things. Say, maybe possibly you can say, city of so and so, yeah, we'll comply with your lot size requirements as long as you're providing the water.
So can I respond to
Yes.
that, just to kind of give you some, for informational purposes? One, we are beyond the days of strict jurisdictional lines for fire departments. The big cities often respond miles outside. City of Fayetteville will respond all the way down past Greenland into West Fork if it's needed. City of Springdale will do the same thing. The cities are already responding. We are very fortunate in this county. This is something that I have learned because I grew up at a time where there were strict jurisdictional lines and you didn't cross those unless somebody asked you to. We're well beyond that with our mutual aid. We are very fortunate here in Washington County that anytime there's a fire, everybody that can responds. The cities don't limit their fire trucks to the city limits. City of Fayetteville, City of Springdale, those trucks travel outside of the city very regularly. And so we have really good mutual aid. I will tell you that there's probably not one fire unless it's really in the middle of the city of Fayetteville or the city of Springdale. But you get out to any small city or any unincorporated area, and you're going to have multiple agencies responding to a fire. You have adequate trucks. You have a lot. So those things I don't see those as issues for us because we're well beyond that, thankfully, unless something changes and the relationship deteriorates for the fire departments, which I don't see that happening. You also have to understand that that cities already have this control over a lot of the things that go on with subdivisions. When we talk about lot sizes, we're really talking about lot splits. We're not really talking about subdivisions. They already have that control in subdivisions. We're giving this control to non-subdivisions that are in that future growth area. And so we're not, we have to also understand that for a subdivision to be vibrant, it's going to have adequate water. It's going to have to have adequate sewer and drainage. People are not going to buy houses in there. And developers aren't going to develop land where they can't make money. There are lots of old subdivisions throughout the county that were plotted that were never fully developed because you still had your own individual well water, you still had your own septic system, and it just wasn't a viable option for people. And so I don't think with our growth, I don't think those things come into play for us, fortunately. I think we've grown beyond that for some of those areas.
Well, let me be a little more specific. Would you have a problem with quarter-acre lot sizes in an area, say a mile from the city limits that does not have city sewage?
Would I have a problem with that?
Yes.
I mean, I don't know that the Arkansas Department of Health is going to approve a septic system on a quarter lot. So if there's not sewer connected to that, some sort of sewer system, whether it's an individual system or it's tapping into a local city sewer, the Department of Health still weighs in on all sewage. That they are the czar of all things sewer in the rural areas of the county. They're not going to issue a permit, which means you're not going to get that. That's not going to be an option for them.
So are we gonna just say we're okay with that if the health department's okay with it?
So let's clarify. Subdividing land is not it doesn't mean a subdivision. Subdivision has a process, and part of the process of the subdivision to be approved for drainage, fire hydrants if it's necessary, and septic. So let's say you're not close to an area that has a sewer system, you have to have septic. It's either individual septic for each lot, or it has to be a community. This is not going to be approved by the Washington test. The Department of Health has to be approved by the state. So they have regulation when it comes to subdivisions, and it's very rigorous. They have lots of conditions. So subdividing quarter lot or 10 acres in a subdivision, it has to go through the whole process, the whole conditions to be approved, regardless.
Yeah, that's not something we don't have oversight of that. When it comes to sewer, that is the jurisdiction of the health department. They issue all of that. I know we talk a lot here on CUPs and sewer, and maybe that was something that a lot of y'all didn't understand. We as the county don't oversee that. That is the Department of Health. That's a state law requirement that those are the individuals. That's the entity that approves sewer in all of its glorious various fashions.
Are we gonna be, with our new regulations, are we no longer gonna be having to look at any of that?
No, we would still look at all these things. If a city opts in for us to enforce their requirements on non-subdivision, then we will simply be applying their standards. But they still have the cities have high standards. It's not like people are just going to have carte blanche to do whatever they want. They typically have more strict and stringent standards than we do.
Yeah, they're very aggressive when it comes to planning.
So we will be applying a more stringent standard is basically what we're doing. It takes what we have and beefs it up. And that's what we'd be applying to that. Does that help out at all?
I don't know if it does or not.
We can have a talk about it sometime.
All right. Thank you.
You're welcome.
Justice Rio Stafford?
Thank you, Judge. We are a rapidly urbanizing county, and all the predictions say that within the next 25 years that our county is going to double in size. So I wanted to thank everybody who's put time and effort into this, because I think it's really important for our county to get ahead of that and to get a handle on that, because the growth is coming, and this is going to have an impact on what our county looks like in the next several decades, what we decide here with this. And adding these additional zoning districts, to me, makes sense. I did have a couple questions.
Sure.
A follow-up to my question about the territorial jurisdiction. So right now, my understanding is right now, like say for example with the city of Fayetteville, 3 miles outside the Fayetteville city limits, development that happens out there goes to technical review to the city of Fayetteville. So I just kind of wanted to understand a little bit more about what would be changing with this. Say, for a city, you know, a larger city of that size, would cities be able to impose, maybe impose is the wrong word, but to allow projects that wouldn't necessarily fit into one of these zoning codes, you know, designations that the county has? Say, for example, a mixed-use project that borders on the city limits but is just outside the city limits.
No, so the county has exclusive jurisdiction, even in those territorial jurisdiction areas, even when the cities are exercising their right to enforce their standards pursuant to state law. Zoning still lies in the city. We cannot give up our zoning. We cannot give that to somebody else to make that decision. We're not allowed to do that. We cannot give up our roads. Roads are still exclusively with the county until the city annexes that land in. Then they take over those roads.
Okay.
To be real honest with you, and a lot of people don't realize this, the way the law's written is the county has exclusive jurisdiction over every road in the county that leads to the county courthouse. And we don't exercise that because we don't need to, because there's a lot of, you know, that's like the sheriff's office has the authority to enforce laws throughout the county, even in the cities. But we don't. We work with our partners so that our money is not going to there when it's not needed. If there's help needed, there we can do that. The county could come in if there was a pothole here on College, right out here front, could come in and patch that if the city didn't do it or couldn't do it. And it's not an illegal exaction. It's a valid use of taxpayer funds. So when it comes to land development, zoning is something that we cannot give up. We will have to zone. Okay. Roads are something that we cannot give up. We will have to do that. And then the cities will even let you know that we have to be the one that approves any lot changes, lot divisions, anything like that. That has to be approved by the county before the city can even come in and do anything. This is where we've had some issues in the past. It's not that the county hasn't wanted to abide by the city of Fayetteville's, you know, regulations because it's right there. It's that we couldn't, and we don't have a mechanism other than an ordinance changing what we do. And so this is going to allow us to now have an ordinance that says we can enforce and utilize their standards if it's in their jurisdiction area, if that's what they want. We are truly trying to be a better neighbor to our cities so that we can help foster their growth, because their growth helps us as a county as well.
So a concrete example, you're saying, of what this would additionally allow cities to be able to do in their territorial jurisdictions would be like lot splits.
That's exactly right.
Okay.
That's really what we're talking about.
Okay.
Yep.
All right, that makes sense. The question came up because the Fayetteville School District just bought a piece of land near Crossover and Joyce, where they plan to build a new school because there's overcrowding on the east side of the city, and it borders on the city limits, so it borders on county land. And there's been some interest among folks there in making sure that there is the opportunity, if property owners so desire, to develop the land that borders the school in a way that maybe some walkable neighborhoods appear in there.
Sure.
So it sounds like maybe the lot split, giving that right over, if the city so chooses to do that, might be something that might help facilitate that.
Absolutely, and this quorum court could look at a zoning map and say, you know what, where we would normally put this in as commercial, we're gonna take this out and keep it as residential because that's what we think is going to happen with this school going out there. We're going to go ahead and prepare for that. That's all up to you when we do this initial zoning map to look at those things and those types of issues to make sure that we're planning accordingly. We're not going to get it all right. This isn't going to get it all right. I'm not here to tell you that we fixed it, right? I'm just here to say we are putting our best foot forward at this point, and hopefully together we will come up with something that is better, not perfect, but better for everybody, that we can all, at the end of the day say we did a thing and it's good, and I can live with that. I can live with that forever, knowing that we did something and we put our best foot forward and we tried to take care of everybody involved.
Yeah. My next question has to do with the use table. and something that's become kind of a really hot button topic in Arkansas, which is data centers. I know right now, last year the state legislature passed a law that kind of limited what cities and counties can do in terms of putting restrictions on data centers and things like that. If they already existed, would we be able to, say, specifically list out data centers as a use in this table,
Yes.
since we don't have that yet?
And so a lot of counties, the majority of counties in the state passed ordinances before that law went into effect that
Yeah.
protected them from these data centers. We did not. And the reason we didn't, because we already have laws in place that protect us with the way we have zoning. Those data centers have to come in as it stands now, and they'd have to get a conditional use permit in the county, and all these factors about the use and enjoyment of land and everything that you consider would go into consideration on these. So we didn't feel a need to pass anything because we're already protected, because we are literally one of 2 or 3 counties that has any kind of zoning in the county. But absolutely, this is our base. If there are things that we need to add, those are certainly things that come up. We're not going to think of everything. And when Jeff Hawkins did this, I don't think that was on there. I think the legislature is going to come back and kind of undo what they did, because I think they
Hopefully.
realized the problems the inherent problems that are with those facilities, which is good. But we can certainly, when we get ready to do this, we can certainly put them in an industrial classification and even still make that a conditional use, if you wanted to. I mean, we've just kind of drafted a template. This is yours to actually fully and robustly incorporate and write the way you want it in the way you see fit and pass.
Yeah, remember the zoning application has to come before you and need to be approved. So if you see a need for any conditions to be added, or maybe the whole thing not to be approved,
Yeah.
that's gonna be your power to approve it or not. So one of those questions is if they're gonna build next to that school, you can say we can zone it, or I don't think that's appropriate.
Well, and a denial, if you look at this and say, you're asking us to change your zoning, we know what you are, what you're wanting to do, and we have serious concerns about these things with it being next to this particular piece of property, and therefore we're going to deny it.
For a lot of people with these data centers, it's noise.
That's your legislative right. And as long as you express why it is, not just, you know what, we don't like data centers, so go find somewhere else. That's arbitrary and capricious. But if there's a legitimate concern and you articulate that, which is why we always ask you to kind of talk about why you are denying a CUP, because it really, the approval, not so much, but the denial, you've got to have a legitimate basis for doing that. And as long as you do, you make my job easy on saying this isn't arbitrary. Court, you don't have to agree. But you just have to find that their reasoning is so far out there that it's arbitrary and capricious. That's a really, really high bar for someone to get to.
Gotcha. So it sounds like maybe by not listing data centers as one of these uses in here, that we move it into the CUP process.
Well, it's certainly a zoning issue first.
Yeah.
And because if it's a CUP, if it's conditional use, you have to have it in the zoning somewhere and then say it's conditional. If
Gotcha.
you don't have it at all, then you have the right to say, we're not going to zone this as whatever it needs to be for this particular purpose. I mean, we can guess, and the courts can change their mind 100 times between now and us passing something. So it's really hard to really prepare for those. It's good to see those and see what we can do, but sometimes we just have to grit it and go with it and let the cards fall where they may.
Gotcha. Okay. I have one more question. I think it's more for the county judge. What do you see or anticipate, if we move forward with this, if we move forward with a zoning map, if we create commercial corridors, what impact do you see on our road department and on our utilization of resources or focusing our resources, in different areas?
Well, that goes back to what I was saying before, where we get caught up on the zoning, but for me, it's planning.
Yeah.
Right now, what breaks my heart is if a project comes to us and they say, well, it's not good because the county road's not good. Well, we try we try as much as we can to make sure all of our roads are good. But right now, it's very difficult for me as county judge to plan where we're putting improvement resources and things like that you might associate with more commercial or industrial districts. Right now, we're just scattershot all over the county, and I can't. It's very difficult for me to plan in that regard.
Yeah.
If that's what you're asking.
Yeah.
If we had certain designated zones, that absolutely would be a variable and an input to these decisions that would let us know where we need to bring roads up to higher standards than just our chip seal or that type of road project.
Great, okay, thank you.
Justice Dean?
Thank you, Judge. Just a quick one. How will this affect people that live in a residential neighborhood and come in and apply for a cup?
Well, it's going to make it very difficult.
Very difficult.
So first off, even for a conditional use permit in a residential area, it's got to be listed on our matrix. It's got to be something that's allowable with a conditional use. If it's not allowable with a conditional use, then there will have to be a rezoning request. And in the middle of a neighborhood, that's where we get into issues of spot zoning. It's going to be difficult for the quorum court to justify legally how we do that. Okay. And so it's going to kind of deter that. Now, read through here, because there are some things that it talks about that, won't require a conditional use permit, home offices type thing where you don't have any customers, you're not putting up a sign, things that we probably normally don't even know about when they happen. Right. And then there are certain things that are allowable with, under conditional use. And so, if it's something that's allowable with conditional use, they're going to have to come in and ask permission. If not, they're going to have to request rezoning.
Okay, thank you.
Sure.
Justice Wilson?
Thank you, Judge. I appreciate all the work that's gone into this, and I welcome the discussion with each other and certainly with constituents, and we can see how that goes in the days ahead. But I welcome it for one reason. I believe, and we all know this, there's a lot of counties in Arkansas would love to have this set of problems, and we've all been to those counties. But one county that I don't think is like, there's some counties that just struggle to get more business there. Benton County's not one of them. They're our neighbors, and be that as it may, are there a lot of similarities? Have we been able to borrow ideas from them when we consider what we're doing? Will we be doing that in the days ahead? Or even though they're in the same boat as us, are they still a different animal when it comes to those things?
I believe, and I could find out later that I'm wrong, I don't believe Benton County has zoning. They do building permits, and the county oversees the county building permits, which to me is a whole different animal to get involved with. You've got to have a big department of people going out to do inspections. And so while they don't really have the zoning that we have, they do issue building permits. So we're a little bit different there.
So are they still addressing the problem, but I guess doing it in a different way?
Yeah, I would say so. I believe so.
I would just chime in there, if you will, and let me say that Judge Mooring and I have a lot of discussions about the similarities and the differences between our two counties. And I face this a lot in my job. Benton County is an urban county now, by and large. I mean, I think their unincorporated land, I would like to say, is a lot less than Washington County's. And so there's a lot of times where I would compare ourselves and take things from Benton County. I don't know that this would be the area that I would suggest that in.
Okay, thank you.
If I can just wrap up.
Sounds good.
So I just want to say I appreciate the time. I'm sorry, J.P. Koger has a question.
Justice Koger?
I was just waiting to see if some of the others answered some of the questions I have, but I need to understand, like, right now, if this is passed, someone would come to the administrative officer, whoever that is, and they would help draft an ordinance to bring to the court, correct?
For the zoning?
Yes.
No, they would help. They would look at the property, look at what they're asking for, and the administrative officer, the planning director, would determine whether or not it was properly zoned or if there's going to be a zoning request needed from the quorum court. If it needs a zoning request, then there's notifications that have to go out, and Director Atta's office would get in touch with the county attorney's office And we would prepare an ordinance for a county services meeting like this that is a rezoning of a certain piece of property. And we would put in there what it is they're wanting to do and, you know, what we're changing it from. And then it would come to you like anything else, and you would look at it. We'd send you a map. You'd see where it was, what's around it, and then you would ultimately look at it and make the determination as to whether or not it fits for rezoning and whether or not you think that it should be rezoned. And if not, you would say, you know, we don't, or we do based on these criteria, and then you would make your decision.
Okay, so say the ordinance comes to us, and will it be just to either approve or deny? Because it's, if I'm reading this correctly, after we vote on it, it goes to the administrative officer, and they set conditions, like sometimes we set conditions on hours of operation and noise, and I don't know, things like that. So are we not going to be able to do that?
No, that is not what the Corps, and I'll be real honest with you, I'll let you in on a little secret. We're real fortunate that we've not had a lot of challenges on that. That's one thing Jeff Hawkins has harped on for the entire time I've known him, is the dangers of the quorum court setting conditions. There's a lot of reason behind that. Again, he's the expert, and he has said numerous times, y'all really are on thin ice. If somebody challenges you on this, you're going to find yourself losing. The quorum court should really not get into the business of setting conditions. You should set policy, and we should ensure that that policy is being followed through the planning department, and those conditions are based on our policy. And so, yes, this is one thing that we're trying to hopefully not have come up as an issue. Now that I've said it publicly, let the games begin.
Okay, so basically then, the quorum court is just going to approve or deny. And
The zoning.
Zoning, and then we're out of it.
That's correct.
Okay, so let me think.
Right now, the planning board will still be hearing these, and they'll still be approving the technical aspects. It won't just be our planning team. So there will be time for the planning board to come in. The people that we put on the planning board are professionals in the real estate and development. They understand that. The courts give a little bit of deference to them because of that. And so when it comes to that, what really needs to happen is we really need to make sure that our policies are being implemented more than anything. And that's the same thing with Director Atta when they do conditions. Fortunately for us, we've had a lot of applicants who are willing to say, hey, I'll agree to this condition, I'll agree to that condition. We might not have a lot of leg to stand on to enforce that otherwise, but if they agree to it, they agree to it. You know what I'm saying? So there's a lot of those conditions that, you know, people are wanting to build, they're wanting to get this approval, they'll agree with what we're doing, they'll agree to do certain things in order to try to get that, and that helps us in that process.
Okay, so if we approve or deny whatever the administrative officer brings, and someone wants to appeal, is that when the appeal starts?
Yes, and that'll be an appeal directly to circuit court. And again, it's an arbitrary and capricious standard because it's a legislative act.
Okay, so when does the planning board come in to set, or whoever, to set conditions like noise control and hours of operation?
That all happens, so the land has to be zoned properly first. We won't go past that. If the quorum court says no to a zoning request, it's over. And people don't have to spend any more money, and they know their answer is no, and that's not going to happen there. They need to find a different piece of land and try to go forward that way. Once it is approved or it is found that it's in a properly zoned area, then that process starts, the actual development, the schematics, the design, all of that, like it normally happens with the planning board.
Okay, I'm not going to ask all the questions I have about it tonight, but I do want to hit on a couple of more things. You said the health department weighs in on the septic. Who weighs in on the building codes and the protection of waterways and drinking water? And these are questions that constituents have asked me, and I don't know the answer to.
So the drinking water, the waterways and drinking water, that all resides with the Arkansas Department of Environmental Quality. They handle all the water. We have no jurisdiction over the waterways. We as the county still have to get permits anytime we're out working in a waterway, just like anybody else does. As the building code and building design, we don't have a department that oversees building code and building design. And a lot of the city, there are several cities around here that don't do building codes either. that's just kind of, it's just one of those things. And I don't know really what to tell you on that, because it's a whole separate issue, but that's not something that we weigh in on. Now, when it comes to commercial and industrial, there are certain, like there's building codes that have to, international building codes that have to be followed for certain things. Really, the only building codes that we don't regulate are residential building codes. Commercial building codes are a whole separate thing. It has to do with your insurance, whether you get insurance, whether you're able to conduct the business you're doing. I mean, there are certain things that go into that. The fire code comes into that with those. We just don't do it with houses.
Yeah. Also, like most people in the county, they either like build a house or they have like a mobile home. Mobile home, it's already regulated. They bring them ready with all the conditions that like it's being approved by like everyone else like in the state. Building homes mostly like is done by professional who's been building in the city, so they build according to the city standards. So it's always higher than like normal. I've never seen anyone who is building a house just decided like to do whatever he wants. No, seriously, without going through the plumbing code, the electric code, like the fire code, all of it. So like there is always something has to be attached to a code. Besides, on top of all of this, whenever we do any of our tech reviews, we have an engineer, the county like engineer. He will like review everything. What says like, based on your code, this has to change. Based on your code, this has to change. Or this is like not. I don't think that's like appropriate. You have to change it to this. So we have civil engineers also like look into everything. It might look easy when we come to the planning board, but we do a lot of work within the 5-week cycle that we don't like share with everyone, but we have it when we post online the staff report. Everything we've done between the beginning to the end is there. And some of the projects we have, if you look into the subdivisions or like anything we do, it has about 300 to 400 pages staff report. That's all being done because we collaborate with lots of like stakeholders.
Okay. Would it be possible, Sam, to change, right now as it is, someone has to give notice to landowners up to 300 feet, but I hear a lot of complaints from people in the county who thinks that should be at least 500 feet. Would that be something that this court could change?
Absolutely.
Okay.
That's your prerogative.
Okay. So my next thing is more a suggestion, but I don't know how to go about making it into what we do. But I would like, this is going to impact the county forever, what Washington County looks like. It's very important. And I appreciate that we're not being asked to rush, into this. But I want to ask if we can have town hall meetings throughout the county where citizens can come and ask questions and get answers. Because there's going to be a lot of questions. I mean, I've got 2 pages here. I'm not going to go into them tonight. I know everyone's tired. But could we do that? Could we have town halls and let citizens come and ask questions and get information?
You all can have all the town hall meetings you want. We can't stop you from that. I mean, I don't have to approve that. The county judge doesn't have to approve that.
Well, I don't know. I can't have a town hall because I can't answer their questions.
Well, and what I was going to... So that's a question for you to address the county judge. What I was going to say in closing is, as you get questions or have questions, feel free to email me or Director Ada those questions. We'll be happy to look into them and get answers back to you to try to help you get those answers back to your constituents. And as this progresses and we have these public meetings like we're doing today, we'll hear constituent concerns. We'll be available to talk. We'll be available to answer questions, the questions you've gotten. I don't know what that looks like, but I just wanted to make sure you all knew that, we welcome your questions and any ideas you have on changes before we roll this out as an ordinance.
Thank you, and I appreciate that, and I appreciate all the work that's gone into this. I can see that it's a lot. Well, another thing I would like to suggest, and maybe would be when you talk about if we have questions, we can email you and get answers. Could the county have some kind of public portal where we could submit those questions and then residents could see the answers and everybody, instead of everybody asking the questions, they could see what the answers are just by some public portal?
I mean, I don't know how to do that, but I'm sure there's absolutely a way to do that. That's certainly something that I will talk to my boss about, to the administration, and see what we can do to best accommodate people.
I would just, some place you might go to, I'm just suggesting this.
Sure.
Is the city of Fayetteville has a FOIA on their Freedom of Information Act page. But they don't use it, but they have an option there where it's supposed to be where where everybody can see every FOIA request that a citizen makes to the city of Fayetteville. So something like that is what I'm thinking about.
Sure.
Thank you. That's all I have, Judge.
Thank you, Director Ada, and thank you, Counselor Lester. I certainly appreciate all the work and appreciate you guys being open. Starts a long conversation, and as Counselor Lester said, please email your questions or give us a call or come in. We'll try to get everything answered. With that, we're going to move on to item number 8, and that was a discussion on a personnel policy by Justice Lemming. Justice Lemming?
Thank you, Judge. In the past years, we've worked hard to get our employees better pay and try to get all of our employees better raises and better money. And we've got, it seems like, I don't know why it seems like it to me, that we are still pushing our older employees that's making pretty decent money. We seem to be moving them out the door. And I just, in this handbook of ours, Washington County Handbook, in page 68, the wording, it says in the termination, Washington County is an at-will employer. Employer with Washington County may be terminated at any time by the employee or the county for any or for no reason with or without notice. Any agreement and all that at-will relationships must be in writing and signed by both employees and employer. I think that needs to change to where the employee needs to be wrote up at least 3 times before they're just, you can just walk in the door and say, see you later for 25 years or for 15 years or 10 years of employment that's been a good employer that's been fired for no reason. I think at least we ought to write them up and go through the procedure a little bit different.
Well, of course, Justice Lemming, I bristle at this because I think there's some incredible insinuations going on here that I think are not only detrimental to me as an elected official, but they're detrimental to our other elected officials and they're detrimental to our workforce. So first, I'd like to know what has given you the indication that it's our goal to get rid of our tenured employees?
Well, you know,
because I can guarantee you that's completely antithetical to where I see it.
Well, whenever a lady been here 25 years and she gets terminated for bad attitude.
And what I would invite you to do in those situations is come and talk to us. You've received one half the story. The reason our handbook's written that way is state law.
No.
It's federal law. Excuse me, counselor corrected me. And secondly, there are offenses in this world that are terminable upon the discovery of those offenses. And so I think any way that you could try to tie our hands to require us to do certain things that you see fit in the management day-to-day is first of all going to run afoul of the Constitution. And second of all, I would caution you about that handbook because once again, in a large way, that's always based upon federal or state law.
That's going to be what you say.
It's
and
what
if
I
it's
will.
The law, it's the law.
It's what I'll say under the threat of law.
If
I mean,
it's
it's
the
not
law,
that I
it's
take
the
that
law.
lightly or that I'm trying to sell you something. Additionally, this form, I appreciate it. It looks like a starting point. I haven't had the chance to review it, but what I want everybody on this horseshoe to understand is we're on the same team. If you have concerns about this or you'd like to implement things like that, we're always open to good ideas. We'd love to hear about them. But I think the tact you're taking is in completely the wrong direction, is what I would say about it.
Well, I just want the folks around the horseshoe to look and talk about it and get it in their mind what they see.
Mm-hmm.
And if
we're going to
it's
do
just
that,
me,
if we're going to do that, we're going to talk about fact. We're not going to talk about insinuations.
Most of the facts that I have comes through. It can be got at your HR's office if you need to see it.
I don't need to see it because I work very closely with our HR department.
Mm-hmm.
And what I want everybody on this horseshoe to hear is, anytime we make staffing changes, It's a very difficult decision for us to do as a county. It's a very difficult decision for me to do as a county judge. But unfortunately, sometimes those decisions are necessary.
I don't disagree. And it's not saying that you shouldn't be able to terminate anybody you want to, but it should be done in manners where you don't have your whole county worried if they got a job tomorrow.
And what I would invite you to do is to be a representative of us as a county and come in to discuss these matters with us first before throwing around the insinuations. Now, if we've erred or we've done something wrong, we will definitely share that with you, and we will let you participate in helping us fix that, because my workforce is one of my number one stress points in my job, is to make sure we're taking care of these people. But it does no good also to that morale for you to make false accusations against us as an employer, and I hope you can understand that.
Thank you.
Item number 9, public comments. Do we have any public comments this evening? 15-minute public comment with 12-minute public comment with 3 minutes per individual. Please come forward, state your name and where you're from. Ms. Moore, you're going to have to hit that button on the very right for me.
Okay.
I think you're live.
Thanks for having me. Sarah Moore, Fayetteville, Arkansas. I'm the Executive Director of the Arkansas Justice Reform Coalition. First, this is not part of my comment originally, but I did want to thank you about the diligence that's happened with planning. Living in the city of Fayetteville, it's incredibly important what happens with the county and the way that our communities come together and all the growth that's coming. So I appreciate all the diligence on that and appreciate the additional conversation and thoughtfulness I know will happen in the future. So thank you on that. I wanted to bring to folks' forefront the crisis stabilization unit. I know that unfortunately has been kind of an ongoing conversation and a point of frustration for many of us in the community about its possible longevity. Mental health in the state of Arkansas is in crisis. Those are the words that we're using in the legislature. And unfortunately, the crisis stabilization units, or the one here locally in Fayetteville, serving Washington County and this local catchment area, have seen some additional struggles that some of the other units haven't. The state is struggling to determine exactly what the funding mechanisms will be for that going forward. I hope that they'll step forward. But at the end of the day, I hope that we recognize that this is an incredibly needed resource in our communities. It's a life-saving measure for so many of us in the community, for our family members, to get a medication adjustment, to stop from ending up into additional acute care, to potentially, end up with potential that somebody tries to end their life, unfortunately, which, ultimately happens when folks aren't able to seek care. I was able to go to Little Rock on Friday and listen to the study that happened of the units in Pulaski and Sebastian counties. For the participants that they studied, those individuals had less involvement with law enforcement going forward. They had less acute hospitalization, and they utilized additional health care means that end up making a safer and healthier community. And so I recognize and want to say, there are a lot of complications. There are, hurdles and things for us to work through. But ultimately, I think that the partners, the nonprofits, the health systems, and the city and county entities working with state officials can get this figured out. And I hope that we'll all stay in that conversation, because it's a really needed resource, for my loved ones, for your loved ones, and really for the safety and the health of our community going forward. We need more resources around healthcare and not less. And I think it's just one more tool in our toolbox to have that in our community. So I hope that you'll stay in those conversations and explore what could be possible to make sure that that stays in our community. Thank you.
Thank you, ma'am. Public comments.
Sherry Main, 15451 Riches Road, Fayetteville. I printed out all 98 pages, have them color-coded in different highlights. So I'm not going to have time in 3 minutes to go over all of this, and I'm glad y'all are just discussing it because it's a lot. Having been around in 2006 or 2004 when they first started under Judge Hunton's administration to do countywide zoning, I was there, I was in on that. So I have a lot of history back behind this, and protecting, my main concern is protecting agricultural and residential areas, and that's the para task force. So my question is, when you say a committee will review the recommendations to the full quorum court of this, along with the zoning maps, the forms, the other 86 pages we didn't get with this, because there were 176 pages total. And we'll review all of that, and it's recommended to the full quorum court. What committee will review that for recommendation to the full quorum court? Will the para task force be reinstated and the judge appoint members to that committee? I know that was a long time ago when that task force was originally appointed by Judge Hunton, but a new one could be formed. I just think this needs more review, more input, outside input maybe from just the people around this horseshoe that have a lot of interest in it, and I think they need to be heard. I, for one, would be willing to be on a committee, a member of a committee, to go through this and go through all of my highlighted things in here and things I see. This is a draft. This is a start, and we need it, and it is a good start. I'm not opposed to it. I'm just saying we need to carefully go through this and make sure we have it as right as we can possibly have it when we pass it. Because if you don't, you'll be like 2007, 2008, 2009, when we did all the amendments to that original 2006 passed ordinance. And I was in on all of those too. There was a lot of mistakes. We fixed those mistakes, but there was a lot of amendments, stuff people weren't happy with after the fact. So let's try to get it right in the beginning. One question I did have, I want to make sure I get my head wrapped around this. I understand the quorum court's review of the rezoning ordinance request. If it's not in C1, C2, the industrial on the zoning map, if it's not in approved with a P, then it has to go for a CUP.
Ms. Main, your time has expired. I welcome you to submit your questions, and we'll try to get you answers as quick as we can. Public comments. Any other public comments?
I'm sorry.
With that, we'll be adjourned.